I can, let me just check. I was going to put back on for the, huh? Okay, all right. That works. So Mr. Eppinger, okay, Mr. Geary and Mr. Siminoff and Mr. Eppinger, I'm going to go ahead and put this back on for the 8th of September for arraignment and status. We'll see if we can get a C3 attorney appointed for him and get him arraigned and otherwise take up any other issues as it pertains to Mr. Eppinger on the 8th of September, okay?
Your Honor,
Sure.
we need to hold him. He's in the conflict motion as one of the ones we need to talk to, so.
Well, since he doesn't have an attorney.
However the court wants to do that. I just wanted to bring that to the court's attention.
Yes, sir. Yes, sir. So we may need to, as it pertains to Mr. Eppinger and any other conflict, we can maybe, that's why I would probably deal with that on the 8th.
Yes, sir.
If his counsel is also ready to deal with it. So we may not be able to do anything with that, but I appreciate you telling me that, Mr. Geary. Okay, all right. So, Mr. Siminoff and Mr. Eppinger, we'll go ahead and put it back on for the 8th of September, and we'll see where there are some other ancillary issues that I need to take up, but we'll wait on that on the 8th of September, okay?
Yes, Your Honor, and that concludes my business, I believe. I may be excused.
Yeah, Mr. Siminoff, if you don't have any other business, and Mr. Eppinger, we'll see you back on the 8th of September, and if you do get a C3 attorney, that lawyer will reach out to you hopefully before then, okay?
Yes, sir.
All right, see you then. Take care.
Thank you, Judge.
Okay, position number 3 is the state of Georgia versus Miles Farley, 22 SC 182273. Mr. Farley.
Good morning, Your Honor. Anastasios Menendez on behalf of Mr. Farley. We're here for a motion to reconsider bond.
Where's Mr. Farley? Let's see. Mr. Farley, can you raise your hand for me, please? Mr. Farley? I'm sorry?
Good morning. This is Lieutenant Dooley.
Good morning, Lieutenant Dooley.
The screens are jumping around on me. I saw a gentleman standing outside of booth 3 on 6 South.
He is on 6 South, Your Honor.
All right. Let's see. I don't see him on any of our, Madam, can you facilitate, oh, is this him right here? Let me see. Mr. Farley? Mr. Farley? I don't think he's... Lieutenant Dooley, can you see if you can help us out with locating Mr. Farley, please?
Yes, sir.
All right, thank you, madam. I'll hold this, Mr. Montanez. Okay, let me hold that for just a minute.
Yes, thank you, Your Honor.
All right. This number 4 is the state of Georgia versus Antonio Sledge, 22 SC 182273. All right, Mr. Sledge, if you were on our platform, could you please raise your hand? All right, Lieutenant Dooley, can I get your assistance on number 4 as well, please, Mr. Sledge?
So, Judge, when my
Madam.
staff called the floor this morning, the we called in the order in which we received the calendar, basically. So the Zoom motions hearing calendar was called.
Yes, ma'am.
So there was somebody in 5 North earlier. So we gave the floors the names in the order of basically that the calendars were stapled together for us. So people may have been moved around. So I'll just need a moment or two to kind of get them to play musical chairs.
Okay, I mean, I'm patient. We'll see, we'll work with what we have.
All right.
And I may have to do that. I may just have to kind of just move to something else, because let me see if that may be the issue. Is Jahandra Seabrun here? Let's see.
That's South Annex, it should say.
All right, let me see if they're on. I thought I saw the South Annex just a little while ago, but Mr. Theory, good morning, sir.
Good morning, Your Honor.
Sir, and good morning, Ms. Salinas.
Your Honor, Whitney Reeves standing in for Ms. Salinas. I'm with the Attorney General's office. Ms. Salinas is just on leave, so I'll be standing in for her today.
Good morning, madam. Mr. Seabrun is down in the South Annex. I saw them on earlier this morning, but I don't know where they've disappeared to at this point. So let me see if we can't relocate them. You'll have to hold for just a minute, okay?
Okay, Your Honor.
All right, thank you.
You're welcome.
All right, do I have Marcavis Huey on this morning? Marcavis Huey, Mr. Huey.
Good morning, Your Honor. Carter Matthews.
Good morning, Mr. Matthews. I may have to hold your client, you as well, because I don't believe we have your client on it either. So just bear with us, okay?
Will do, Judge.
All right, thank you, sir. How about Khalif Adams? Mr. Adams? Khalif Adams? Khalif Adams.
Judge, if I can, Khalif Adams is in DOC. I think we always announce that, but he is in Department of Corrections.
Okay, thank you, sir.
Department of Corrections, he's not there.
He's in there for murder, Judge. He was convicted for murder. He's serving a murder sentence in DOC.
Well, provide me with the GDC number. Checked on most of these individuals.
Yeah, Mr. Gear, if you or your team could give us that, we would appreciate it, and we'll go ahead and do that, and we can then have him produced. So we'll go ahead and set that for 8 September, assuming we can get a GDC number.
Your Honor, DOC shows him in Hay State Prison.
I have the GDC number.
Yeah, if you could, yeah, provide. Okay, thank you. We'll set that over for 8 September.
That's Huey, Judge?
Yes, sir. No, number 7, Adams.
Yes, sir. What's the date again, sir?
8 September, sir.
Yes, sir.
South Annex, are you with us yet? Not yet, not West.
Judge Glanville, may I request something?
Madam, yes, you may.
May we conduct the business of the inmates that we have in the booths and jump around from the calendar? I think
Yes,
it's
ma'am.
going to be, okay, thank you.
Who? All right, councilors, we're going to go ahead and move, since some of these folks that we have on on the Zoom platform are here this morning for proffers, we'll go ahead and take up that matter at this point in time. But before I go ahead and do that, related to that particular case, Mr. Geary, Mr. Smith, and other councils, the 22 SC 182273 matter has been re-indicted and the new indictment number is 22 SC 183572, correct?
Yes, Judge. May I make an announcement, Judge?
Yes, you may.
Judge, we have notified all defense counsel, all counsel of all the defendants who have counsel, that we intend to we were going to file a written motion today in open court because the law requires us to do that. So I said written motion. We have to make a motion in open court to give the defense bar the chance to object, to move to null pros the first indictment, which is 22 SC 182273. We've given them all notice. We herein make that motion to null pros that indictment and proceed solely on the new indictment.
The new indictment being the 22 SC 183572?
Yes, Judge.
Okay.
So that would be our first motion. That should handle that so we can proceed forward. If the court were to grant it, we have been instructed how to present the orders.
Yeah, unfortunately, you'll have to do an individual or order for each particular defendant, null prosing the indictment.
We will do that, Judge.
22 SC 182273, and then the superseding indictment would follow, would be fine. So yes.
If no objection and the court grants it, we'll provide those orders.
All right. Do I hear any objection from any of the aforementioned councils or their representative parties? Mr. Steele?
Morning, Your Honor.
Good morning, sir.
Good to see you, sir.
Always a pleasure.
I feel the same. Your Honor, you may remember we filed on behalf of Mr. Jeffery Williams a demand for a speedy trial. It's very tricky because I don't believe, as the Honorable Attorney Adams and I put in our motion as a footnote in the demand for a speedy trial, I don't believe it really takes root until January 1, 2023. But if I don't object to the null pros of that indictment having a demand for a speedy trial, I waive that speedy trial demand under the law. So as a basis of, I'm not exactly sure how it works with the Honorable Judge Brasher's order, I will object based upon my demand for a speedy trial to the null pros of the original indictment. Don't want to waive it. My point is I don't want to waive anything dealing with the speedy trial demand.
All right, sir. Any other basis or?
No, sir.
Okay.
Judge, we're also prepared to file, if the court grants that, file a motion to adopt all orders and motions from the previous indictment into the new one as well, so everything should carry over.
Okay, all right. I still think he has to object, Mr. Geary, so subject to that, I'll grant them. I'll grant the motion to transfer the current discovery that is found and motions that are found in 22 SC 182273 into the new indictment or the re-indictment 22 SC 182273. And Mr. Steele, I have noted your objection.
Thank you.
Okay, all right. And I'm still going to leave the case on a 9 January 2023 posture for trial.
Aye, sir.
Okay, all right. Does anybody else, any other defendants have any specific objections as to the re-indictment and the transfer of any of the discovery or motions that have been filed? Anyone else? Okay, all right.
I'm sorry, Judge, may I continue?
Yes, go ahead.
Thank you, Judge.
Mr. Geary, if you and your team would just prepare a suitable order for that, I can sign it, then we'll give it back to you and you can e-file it, okay?
Have that to you today or no later than tomorrow morning.
Okay, that's fine.
Also, I wanted to bring the court's attention. We filed a motion basically to restrict We have found that some of our discovery that we have filed, so the court's aware, we have put the discovery in a Dropbox, and we have given only the ones that have attorneys right now access to those Dropboxes. That discoverable information has appeared on social media, TMZ, other such sources. We filed another motion to restrict, to prohibit such things, not to prejudice the defense, not to threaten witnesses. As a result of that release, one of our witnesses is now basically in isolation and protective custody. Him and his family have been threatened. And again, I'm not aware of who, and I'm not making a threat allegation against any particular defendant at this time. I just know that there have been threats made. I want the court to be aware of that. Judge, with the possibility, I'll put it that way, of trial starting between January 1st and the end of April, predicated on 2 speedy trial demands in existence, we're going to file a motion here shortly for a questionnaire. We wanted the court to be aware of that. We think that will expedite and really streamline jury selection. We want the court to be aware of that. And we're also going to, if the court has the ability to narrow it down, and I respect the court's schedule, given the number of witnesses we've got, the subpoenas we're going to have to deliver, and I'm sure the defense is going to have some of the same considerations. But we'd like to know when and if we could get a date certain to at least start jury selection so we can produce those subpoenas and not slow down the trial as a result of our failure to anticipate those needs. I just wanted to put that out to the court as well, Judge.
Okay, so those are the 2 motions outstanding right now. The more immediate one is the motion to restrict discovery, and then the one that's that you'd like to forecast out a little bit would be the motion for a questionnaire. Okay, all right. I'll need to probably set both of those for hearing, so to give all the other related and interested parties an opportunity to respond. When did you file your motions to restrict discovery and for the questionnaire? The questionnaire hasn't been filed yet. I understand that. That's coming.
Monday.
No, the questionnaire hasn't been filed.
No, the one for restrict.
Restrict is Monday.
Monday, Judge. It was filed Monday and served.
Okay.
Basically, we found a lot of information concerning one of our witnesses, basically on a TMZ type outfit.
Okay.
And it's in social media. We've had to put one witness in isolation and protective custody.
All right. I can hear that on the 8th of September.
Aye, sir.
Okay. All right. So I will hear that motion to restrict discovery on the 8th of September. Okay, 9 o'clock.
And Your Honor, in that vein, Kristen Nove on behalf of Mr. Kitchens. Mr. Kitchens objects to the state proceeding via proffer. We want to know what specific threats there are. For example, if something's posted on social media and a witness says, or excuse me, somebody comments, that's ridiculous, somebody should push you off a cliff. That's very different than a direct threat to the witness. So we can do that in camera. We can do that, if the court prefers, we can do that in chambers so as not to put the witness's name out there. That's fine, but there have been many allegations that there are threats to witness, and to date, we have received no discovery, not a single shred of discovery of a witness who is actually threatened and evidence of that. So we requested this time that the state produce some witness, some document, some screenshot, something, so that this can be actually verified when we hear this issue.
All right, Mr. Geary.
If these were actual charges, I probably would agree with counsel. They're not. The statute permits us to do an ex parte reveal. We have done that. We would not want to reveal it even to defense counsel, given the danger or potential danger of these witnesses. So the court's aware of what we know at this point in time, as permitted by the statute, and that would respectfully be the plan that we would expect to follow. We don't want to further endanger. I don't know that we will. I made it very clear that I have no information that a particular defendant has either made a threat or arranged for a threat to be made. I don't know how much clearer I can make that. That they want to know who some potential third party is that I can't even identify in all situations, I think is not relevant. I think the threats are out there. We've made the court aware. There's even been a threat to our sheriff and his wife that they would be killed. That one, we identified the perpetrator, and that person is in custody. It is actually a relative of one of our 28 named defendants. The court's aware of that one as well. So we followed the law on that. The law does not address us giving this information if it's not a specifically named charge, and for that, we have not given that information.
Okay, Ms. Novi, I'll take it up when I hear the motion on the 8th. If you have any written or other law or that you'd like to present to the court for my consideration, just please send it to myself and Mr. Kearns, the court staff attorney, prior to the 8th of September, okay?
Thank you, we will.
All right, thank you, madam. All right, anything else on behalf of the state? So I just have the motion to restrict, and I'll take care of that on the 8th of September. Is there any other things that I need to, we haven't gotten the proffers yet. Do we have any other motions outstanding that I need to schedule?
Judge, the only thing we have is that motion to appoint. We've asked C3 to be present so we can ensure defendants have counsel and have enough time with the discovery to prepare for the court's trial. That's the only one we have pending right now that we filed. But again, we're going to file the one on the questionnaire and the special set. We're going to file that before the 8th.
We have the court has also inquired about from Miss Bernard and Gina Bernard, that is, and I don't know what the posture is on getting some of these folks attorneys. At this point in time, I have been told that there's a couple things going on. One, that we have counsel that they're having a difficult time procuring counsel. That'd be the best way I could kind of overarch it. So, is there anything else to add on that issue?
Other than you stand on the motion, Judge. No, sir.
Yeah, I mean, the court has just such a vested interest in getting qualified counsel, but who has not been appointed a lawyer as of yet? Mr. Geary?
If you give us a second, we'll pull that.
Sure.
Address it in a minute.
Yeah, no problem.
Judge, just for clarification, on the motion to no frost, did you grant that?
Yes.
Then we will give you an order for each named defendant. Did you grant the order to adopt all the prior motions and orders from the no frost indictment?
I did.
Then we will present individual orders on those as well.
Yeah, and I will sign those, and we'll give those back to you to be filed in Odyssey. Okay. Okay. All right.
We have the names.
Your Honor, I have the names of the unrepresented defendants. Khalif Adams, Damone Blaylock, Cordarius Dorsey, Christian Eppinger, Javon Fleetwood, Demise McMullen, Marvius Nichols, Rogelius Ryan, and Your Honor, I believe Antonio Sledge. I think Antonio, someone has since obtained counsel since we filed that motion.
What was the last defendant's name? I'm sorry.
Let me double check, Your Honor. I believe Sledge has not obtained counsel yet either, Your Honor.
I believe he's position 4 on your calendar, Judge. It does not show an attorney.
Yes, so that's the...
Okay.
And then, Your Honor, three defendants are still outstanding, so they have not been arrested, so they don't have counsel either, but I didn't include them because they have not been arrested.
Yeah, we can't do anything with that until such time as they are brought within the jurisdiction for us to do anything with them.
Yes, Your Honor.
Madam, if you'd be so kind as to send me, and you can copy everybody else, the names of these particular individuals, I will turn around and forward that to the public defender. because there is a process for appointment for C3, just like with Mr. Eppinger this morning. I'll have to do the same thing. So, and I'll just see if I can't make another further inquiry. But that's what I have inquired since I got this case, and I've been in discussions with Ms. Bernard and about this and other C3 matters. I'm not the only judge that's having the issue with this, and so we are very constrained and challenged to try and get C3 attorneys.
Yes, Your Honor. Well, I'll send that list to Your Honor, to Mr. Kern, Mr. Chamberlain, and to the group of everybody.
That'd be fine. If you could do that, I'll go ahead and we'll see what we can do. But it's certainly a concern and an issue. So that, and we're trying to address it, but you know, there's only so much that I can do, and I may even have to just kind of see if I can, if there's any other resources for the court to appoint any lawyers. So we'll see how that goes. Okay. All right. Okay. Anything else? Any other preliminary issues? Okay. All right. Okay. All right. Those defense counsel who are here or on the platform, any other issues that I need to be made aware of before I take up these proffers?
We have one, Your Honor, on behalf of Mr. Kitchens.
All right, you got to identify yourself for the record.
Kristen Nove on behalf of Sergio Kitchens.
All right, madam.
I wanted to, I'll get next to the microphone. I understand the state has provided a second additional discovery on our behalf. There's been some issues in actually getting the discovery, and I've brought a hard drive with me because for whatever reason, there's a number of things that we can't download via Dropbox, so we don't have access to it. So if the state will agree, I've got my hard drive here, we can get access to those specific items if that's amenable to the state, since we can't get it via Dropbox.
Mr. Geary or Mr. Smith, anything you all can work out this morning on that?
Your Honor, and let me say this first. We've had people try to download everything and no one's had a problem at this point. I'm not denying that counsel may be having a problem, but I want to put this on the record. If we download everything to a hard drive, respectfully, I don't want the responsibility for them to say we didn't give them something. Everything that's on the Dropbox has been served, and we will make an attempt to make sure that's duplicated if we download on a hard drive. But I want to put the responsibility to the defense that if something is identified on Dropbox that they claim they don't have, they need to let us know, because we've served all the material. And everything we've gotten, with one exception, which we're fixing, is downloadable, is accessible to our knowledge. No one has brought us a problem except a general thing that says, hey, it's too hard, we can't download it. I get that. We've had our people go in and do it, and it's doable. I will, it's extra work, we'll download it for them, but I'm standing on the Dropbox discovery that we've served everything. And if anything's different, I want to put that on the defense bar to say, wait, we didn't get something.
And Your Honor, that's what I'm doing right now. Wait, we didn't get something. If we don't need the entire thing, I think there are 5 folders that cannot be downloaded. We've tried it numerous times.
Okay, which 5 folders are you talking about?
It is the folder 16 through 20. The title of the folder is 16 through 20. 56 through 59, 79 through 81, 85 through 87, and 73 through 76. Those are the folders that we cannot access. So we don't need the whole thing, just those.
Mr. Geary, Mr. Smith, do you have one of your tech folks available at the conclusion of these proceedings so they can go ahead and facilitate those particular downloads?
Judge, if we've not received that particular information, if we can get that information for them and they want to provide a hard drive.
You just did. They just did. So can you do that after court?
I didn't write them down, Judge. If she'll email those to me, yes, Judge, we can do that.
Okay. Wonderful.
And in fairness, we did email the state about this on August 2nd. So we just have not received any response to that. As well as, Your Honor, there is a witness interview that was from 2019 that has not been provided, and I won't say the witness's name, that we've requested from the state, as well as we still, to this day, have not received any discovery about this nurse who allegedly tried to provide some kind of contraband at the Fulton County Jail.
We're not here to argue that. I'll take up that on the 8th.
No, Your Honor, I'm not attempting to argue it. I'm just asking for the state for a status on that particular item of discovery.
Your Honor, I did provide that status to Mr. Sadow. That actual recording is in the possession of a prosecutor not in Fulton County. But we have the reports that discuss the statement. We're getting the physical copy, and I told Mr. Sadow we provide it as soon as it's in our possession, and that remains our answer.
Okay.
And as for the nurse, if we could get a status on that.
I think he's told you what he has right now. So I mean, both of you all have an ongoing duty to supplement if you opt in. So I'll leave you all to do that. You all are very seasoned advocates. I'll get involved if necessary, but you all just need to kind of.
The only reason why we're asking the court to get involved.
Say again?
I said the reason why we're asking to get the court to get involved is because there's been multiple emails to the prosecutor asking specifically for this discovery on the nurse, and the state has still not told us if they have it and when they plan to turn it over, if it's even possible. I can get it today. We've got the hard drive. We're ready to go. We need that information.
Okay, Ms. Novi, I invite you to file a motion, and in the absence of that, I believe Mr. Geary has indicated to you that he'll go ahead and at the conclusion of this, see if you can go ahead and get those other issues of discovery. Okay.
Okay. Thank you.
All right. You're welcome.
And Your Honor, John Garland for Mr. Kitchens. This is just a point of clarification. You had ordered that we had 60 days from discovery to file our motions. And I'm just not quite sure when that clock starts running, given that we've been given a little discovery, but it's clearly not even close to what everything the state's going to rely on. So I'm trying to figure out when that clock starts running, Your Honor.
Well, have you filed anything as of yet, Mr. Garland?
No, Your Honor.
Do you have some discovery now?
Not that would make it to a jury, Your Honor.
That's not what I asked you.
I mean, I do have some discovery.
Okay, all right. Well, then you need to start working with what you have. There, of course, the state has the responsibility to supplement and update. They will, but you need to do what you need to do in order to, pursue your client's interests. I'd invite you to do that. I just wouldn't wait until a magical date in the sand, because I have a feeling that discovery is going to probably be ongoing in this particular matter, given the scope and given the intricacies involved. So I would just invite you to do what you feel you need to do, okay?
All right, thank you, Your Honor.
All right. Okay. Anybody else?
Sorry, Michael Thorpe.
I regret asking that question, Mr. But that's all right. Go ahead.
Your Honor, on behalf of Diamante Kendrick, who is my client, I'll try to be very brief points. First, to add to what Ms. Novak indicated, apparently there is a second set of discovery that the state has tried to provide or provided. We do not have that, and we're not sent that. So if we're happy to have it by Dropbox link, but we need the link. We have not gotten that.
I think that discovery is still subject to some disclosure issues. Is that correct, Mr. Geary?
Sent to you.
No, sir, it was sent.
It was sent?
It was
Okay.
sent to you.
If we need to resend it, we'd be glad to resend it to council, but it has been sent.
And I think maybe some of the issues is that Katie Hingerty, who's in court, is my co-counsel, and she's filed her appearance, but we're not. Maybe she's not on the list or not getting it. But if we could both get that would be.
Okay. Well, you'll need to check, Mr. App. You're a veteran of this process. You'll need to probably go down to the clerk's office and make sure that your e-file appearance is actually shown up. And
we did that.
And have you gone down to the clerk and talked to them as well? Because sometimes it's just a question of the technology just hadn't caught up.
Well, my staff did that.
Okay.
But yes.
All right.
The second issue, and again, I'm certainly not throwing any shade at the court, but I think it's more an issue at the clerk's office or whomever. I just don't know. But for example, we did not get any notice of today's court date. We're not getting notice of when there are motions or other important hearings. And I don't know how to make sure that that happens other than to address it with Your Honor, so that Ms. Hingerty and I can get adequate notice to be prepared, not only to show up, but to prepare for those hearings. I would just request that anyone, give us proper notice.
Okay, well,
so we can be notified of any future court dates.
I believe that the court is more than capable of giving you what's called in-court notice. So, and I do give in-court notices to the next proceeding. So the next proceeding for those particular motions or things that we have scheduled is the 8th of September. Now, whether or not you appear in person or whether or not you appear via Zoom is another thing. But I would just make sure that from whatever system you're using, e-file Georgia or the like, that you make sure that you are in there properly and that there are no other glitches. But but I can deal with one part of it, and that's to give you in-court notice.
We filed 3 or 4 substantive motions in the last 48 hours, Your Honor, particularized substantive motions. Can those be heard on September 8th?
Don't know. What are they? See, the other thing is the court's not an e-file party, so we won't know unless you tell us. So that's why giving us a courtesy copy, either sending that to Mr. Chamberlain or to Mr. Kearns, my staff attorney. I don't know if that was done.
We snail mail. I like to call it snail mail, but we snail mailed a courtesy copy to Chambers of our 4 motions.
I don't know if we received it as of yet. I know that I haven't gotten anything as of yet. Kendrick? Yeah, your client wasn't even on today, Mr. He wasn't scheduled. So you're just an interloper, basically. That's
and yet when I showed up here, I was told that the court was going to inquire of my client today.
Well, I mean, listen, Mr. App, you're always welcome. I mean, this is a public forum, so I mean, you're always welcome to come in, but your client wasn't noticed for anything today.
Okay, so I understand that. Your Honor's telling me that, but when I got here, I was told by several people.
That's because we're attorney and public friendly. So, but no, your client doesn't have any proceedings before us, but you're welcome to ask whatever questions. But the reason that you weren't on is that your client's not on for any official proceedings today. Okay.
So we don't need to make a waiver today.
If you'd like to, I have not asked, and that was one of the things I was going to get to in just a second, is whether or not, because we don't have everyone here today. That's why I was going to set it for the 8th. If you want to go ahead and waive your client's,
I'm happy to handle all of it on the 8th and be excused now, if the court so desires, or waive it now. I'm always here at the court's
What motions did you file for on behalf of your client?
We filed 4 motions, Your Honor: a special demurrer, a general demurrer, a motion to sever, and a motion for time to file additional motions, based upon the missing discovery, or the discovery we haven't seen yet.
No, he didn't. That was the thing. He mailed them. He mailed them. I know. Can we put them on for the 8th? For those motions?
Let me just write his name down.
Okay, fine. Hey, what's that one? Mr. App, as it pertains to Mr. Kendrick, I can go ahead and add him to the 8th calendar for those motions to be heard. You'll get a notice. You're getting in-court notice now. Okay?
I appreciate that very much, Your Honor.
All right.
Thank you so much.
Thank you, sir.
And did you want us to stay and waive that conflict today, or do it on the 8th?
No, in terms of conflict, just wait a second. I haven't gotten to that yet.
Very good.
Okay?
Thank you, Your Honor.
Judge, for clarification.
Yes. Just to make sure, Mr. Geary and Mr. Smith, we are proceeding on the new indictment, correct? The one ending in 572, correct?
Yes, sir. You've no across the previous one. It's the
Yes.
only one that presently exists, Judge.
They're going to get that to you today. Huh?
I'm fine. I just need to make sure that that's where we go.
That Mr. Geary's already null pros the other indictment. He's going to have those orders for you today. The orders to null pros as to each one and to transfer the Yeah, I understand. I understand. They're prepared to give that to us today. Okay. Yes, Mr. Adams.
Yes, good morning.
Good morning, sir.
Keith Adams, Madam Court Reporter, on behalf of Jeffery Williams with Mrs. Brian Steele. Just some clarification, if I can. Is the court asking whether or not there are any other matters other than what's on the calendar for this morning?
Just housekeeping. I usually ask that as a matter of course, but if you weren't noticed for anything today other than the proffers, that's really all we're doing today. And I have some other ancillary business with some arraignments, but other than that, I had planned on, in terms of the re-indictment, to deal with that on the 8th of September. But since some of you are here today, if you want to go ahead and waive arraignment on behalf of your client, have me go ahead and enter a not guilty plea on your client's behalf, and otherwise give you 10 days from the receipt of discovery to file any other additional motions, I'll allow you to do that.
Well, I guess what I was getting at, Judge, is we were noticed to be here today. We're on the court's motions calendar for our previously filed motion for reconsideration of bond. But separate and apart from that, I was under the understanding that we'd be heard on the issue of the waiver of conflict issues
That's
today.
correct.
And one of those specifically involves Mr. App's client, who, as I understand it, is not here. And my recollection is that the court wanted to do those waivers in person, presumably meaning the client or the individual is here. So that person's not here.
Well, we won't be able to do anything with that one then if he's not here.
It sounds then like the waiver of conflict issue
For
is going to be tabled today.
that particular client won't be taken up today because he's not here. I don't know why he's not here. I hadn't heard anything. So, but
are you, if we're desirous of being heard on the motion that's on the calendar, the motion for reconsideration of bond, are you inclined to hear that today?
I am.
Okay. All right. Let me check with co-counsel and see whether, it may be best to table that, but let's, if you'll give us an opportunity to make an announcement on that shortly, I will.
Yeah.
All right. Very
That's
good.
fine.
Thanks.
All right.
Then I assume I can be excused, Your Honor.
Just hang tight until I figure out the other issue with the with the waiver, okay? All right. Okay. Okay, Mr. Geary and Mr. Smith, I am prepared to take up the issue of the waivers at this point in time. Who do we have that we need to take up for those particular issues at this point?
Your Honor, for the waivers that are needed based on the conflicts that we filed for Mr. Williams, so these are people that are conflicted from the conflicts involved with Mr. Steele, would be Defendant Williams,
Okay, he's present via Zoom.
Defendant Arnold, Defendant Greer, Defendant Kendrick, Defendant Stillwell, and Defendant Blaylock. For Mr. Kitchens, the only waivers we would need from him are from Mr. Kitchens himself. Mr. Kitchens would need to waive that conflict. And then the other defendant implicated in that has not been captured yet. So at this point, we aren't obviously asking for a waiver as we,
Is that Mr. Winfrey?
Yes, Your Honor.
All right, that's fine.
And then as for Mr. Shart, we would just need that waiver from Mr. Stillwell, as well as Mr. Eppinger, who we spoke with earlier, who of course is not represented, and Mr. Fleetwood, who is also not represented.
Okay, well, for the unrepresented persons, I can't deal with those yet, or the people who have not been arrested as of yet, or been brought to within the jurisdiction of the court. So I can take up the ones that, maybe we can do this by attrition, and just take up the people that we have at this point in time.
That sounds great, Your Honor.
Okay, all right. All right, so, Mr. Steele, can you come on up, sir, please?
Judge, if I may, on the matters affecting, excuse me,
I'm sorry, I didn't hear you.
On the matters affecting a waiver of conflict, specifically as to Mr. Steele or Mr. Steele's representation or prior representation of the individuals who are going to be before the court, I'm going to be handling that matter.
Okay, all right.
And the court, I presume, will let us know whether you intend to pose the questions to those individuals or whether you want me to do so.
Okay, I have Mr. Williams. I'm going to mark this, Mr. Adams, as court 1, and it is your letter dated May the 18th of 2022.
Yes, sir.
It is a typed document. It has 10 paragraphs, and it's purported to be signed by Jeffery L. Williams. And then I have on the same date, a handwritten letter, which I believe is that the handwritten copy that is typed and reflected on your letterhead?
Yes, Your Honor. The handwritten copy is the exact same.
All right, then I'll leave. That'll also be court 1.
Yes, sir.
I also have a letter dated 20 May from the law office of Lawrence Zimmerman related to Quintavious Greer. I have that one as well.
Yes, sir.
I have a letter dated 31 May 2022 from a Damon Blaylock, who in that point in time was in Wilcox State Prison. It's dated waiver of conflict of interest, and it is signed by Raymond Law. That's L-A-I-L. I have a letter from Mr. Adams, Ed LeVance Adams, involving Martinez Arnold, and that is dated May the 19th of 2022. I have a waiver from Mr. Kitchens. And that's dated 10 June of 2022. And I also have a waiver from, as you mentioned, Jimmy Winfrey, and that's dated 16 June 2022, and that's Miss Rockwell's client. But since Mr. Winfrey's not here, I'll wait until any of the people who are not in custody as of yet, or don't have representation, I won't deal with their waivers at this point, okay?
And I don't believe that Mr. Kitchens or Mr. Winfrey's statement has anything to do with us.
Those are just ones I have, but yes.
Okay.
So why don't we,
Judge, 1 second. May I just jump in?
yes, Ms. Rockwell.
I'd love to sit here and watch all of this, but if y'all are not going to deal with that regarding Mr. Winfrey,
Not yet, because he's not subject himself to the jurisdiction of the court as of yet.
then may I be excused because I was subpoenaed for that by Mr. Garland.
Okay, all right. I mean, Mr. Garland can release you from your subpoena. I don't know how we could potentially go forward with that unless Mr. Winfrey is in fact before us. So maybe Mr. Garland was being extra cautious and making sure that it had Mr. Williams actually, I'm sorry, not Mr. Williams, Mr. Winfrey actually been apprehended or given a bond or to that effect, then we would be able to do something with it.
Thank you, Judge.
So I'll just table it for the time being, madam.
Good to see you, Judge.
Yes, good to see you as well. Okay, all right. So, Mr. Adams,
Yes, sir.
I've marked the typed letter and your client's handwritten letter as courts 1 and 2. Okay.
Yes, sir.
Do you want to go, Mr. Williams? Where are you? Mr. Williams, good morning, sir. Can you hear me?
Yes.
All right. Mr. Williams, did you have the opportunity to read and discuss the waivers, that your handwritten waiver and the typed waiver that were signed on the 18th of May of this year, 2022?
Yes.
All right. I'm just going to go through it with you right quick, okay? It references on this particular date and you are Jeffery Williams, who's born on August the 16th, 1991. Is that correct?
Yes, sir.
All right. It says you've consulted with attorney Keith Adams on the matters contained therein, and you state basically as the following, okay? That you are the same Jeffery Williams charged in indictment 22 SC 182273, and that was the prior indictment in this case. Is that correct, sir?
Yes, sir.
All right, you understand that your case has been re-indicted in 22 SC 183572. Have you had the opportunity to speak with your attorney about the new indictment?
Yes, sir.
Okay. It also references that you're being currently held, and right now you're in the Cobb County Detention Facility. Is that correct?
No, I'm in Cobb.
Okay, that's what I said. You're in the Cobb County,
Yes.
Cobb County Detention Facility. And this contains the indictment 22 SC 182273, and that case has been re-indicted, as I mentioned, in case ending 572. So that's correct. Is that right, sir?
Yes, sir.
Okay, and then number 3 says that you've received, read, and understand the charges contained in the reference indictment, and you're aware that you're being charged in the indictment with other individuals. Is that still your understanding?
Yes, sir.
All right. Number 4 represents that you're currently being represented by attorney Brian Steele and Keith Adams, and that you've been represented by attorney Brian Steele since the date of your arrest on May the 9th of 2022. Is that correct?
Yes, sir.
It also references that you have been represented by Mr. Steele in other legal matters and unequivocally desire his continued relationship, and you also established a trusted attorney-client relationship with Mr. Steele. Is that correct?
Yes, sir.
All right. It also references that you've had daily meetings and consultations with Mr. Steele and Mr. Adams regarding your case and specifically your defense. Is that correct?
Yes, sir.
All right. And then you've met with Mr. Adams, number 6, independently and outside the presence of Mr. Steele concerning any potential conflicts of interest regarding Mr. Steele's representation of other persons named in the indictment as well as you. Is that correct?
Yes, sir.
All right. Number 7 references that specifically Mr. Adams has discussed with you the specifics of the State Bar of Georgia rules pertaining to conflicts contained in the Georgia Rules of Professional Conduct, specifically 1.7, 1.9, and 3.7. And Mr. Adams has discussed with you thoroughly and completely the issues related to any potential or alleged conflicts in this case. Is that correct?
Yes, sir.
All right. Number 8 references that based on your discussions with Mr. Adams, you're unequivocally waiving any and all conflicts and desire in no uncertain terms for Mr. Steele to continue to represent you in this matter. Is that correct?
Yes, sir.
Number 9 references that you're aware that Mr. Steele has represented other persons in this indictment, and notwithstanding any relationship Mr. Steele may have or may have had with any other person or persons contained in this indictment, you waive any potential conflicts. Is that correct?
Yes, sir.
And then number 10 says that you've met with Mr. Steele and discussed that what we've discussed here. After review, the state's motion to disqualify Mr. Steele as your counsel, and that you have stated to Mr. Steele unequivocally and without reservation, and you state to me, the court, that you waive any potential conflict and wish for Mr. Steele to remain as your chosen counsel. Is that correct?
Yes, sir.
All right. Anything else, Mr. Adams?
Nothing on behalf of Mr. Williams. I believe that's sufficient, but obviously
Anything on behalf of the state?
Your Honor, we just simply like to ask just to confirm whether Mr. Williams has been promised, coerced, threatened, anything in order to obtain this waiver.
All right.
Under oath.
Mr. Williams, just a couple other questions. Have you been forced or threatened or tricked or basically cajoled into signing this particular waiver?
No, sir.
Are you entering this waiver, and did you sign this waiver freely and voluntarily? That means it was your own decision to enter or sign this waiver in this case?
Yes, sir.
All right. Mr. Williams, I would tell you that I will, at this point in time, continue and let Mr. Steele represent you. However, I do, if there is a conflict which develops later, you certainly are more than welcome to raise it, or if I see it, I will raise it for your consideration and the state's consideration. But at this point in time, I'm going to let Mr. Steele represent you at this point. But if Mr. Geary, if a conflict does arise at any point in time in the future, I will reconsider this particular issue of representation.
Can I ask the court to do one thing, sir?
Absolutely.
I'm just trying to make a record. Would the court please put Mr. Williams under oath and ask him to reaffirm all the answers he just gave?
Okay, all right. Mr. Williams, can I get you to raise your right hand for me, please? Do you solemnly swear or affirm the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and none but the truth, so help you God, so affirm?
Yes.
I can put your hand down. All the questions that I just asked you, do you reaffirm and reinstate those responses?
Yes, sir.
All right, anything else, sir?
No, sir, thank you, sir.
All right. Okay. All right. And so that will be the order of the court, Mr. Adams. If you prepare a suitable order for my signature, send it to Mr. Geary and his colleagues, and also send Mr. Kearns a copy.
Yes, sir.
Okay.
Yes, sir.
Are we going to do
Sorry.
the other defendants as they're available, Judge?
Yes.
Thank you, sir.
Yes, sir. And we'll see who else is available today. All right. Anything else, Mr. Adams?
No, sir. Not in regards to Mr. Williams specifically.
Okay. All right. Let me table your bond issue. You're going to let me know about that. Let me see who else is on the platform. Okay.
You do intend to question the other individuals?
Are you me?
I'm asking.
Well, let me do my job then.
I'm just asking. Just need some clarification.
I didn't come out here for shucks and giggles. I came out here to take care of the waivers. That's what we're doing today. So why would you ask me that?
When you said if there was anything else, I was
for you, because you told me, said, hey, are we going to handle? We have our bond issue being heard today? And I said, yes. And then you said, well, let me decide whether or not I want to, after consulting with the team, whether I want to do that. But I got other folks I got to take care of. So yes.
Can I just say?
Can you just slink back into your chair? Okay, yes, you can.
Can I just say in response to your question that I understand that there are other individuals who may be on the platform whose conflict waivers in reference to Mr. Williams, and that's what I was asking whether or not you intended to.
Anybody who's here, sir, right now, who's on the platform, who was in fact noticed for today, I'm going to take up.
All right, and with that, I'll take a seat at the table.
Okay, and then you can let me know about the bond in just a minute, okay?
I will do so.
Okay, all right, no problem. Yeah, you can stand on it, yes. That's fine. All right, go ahead. Okay, all right. Okay, so Mr. Gary, who else do we have on the platform today we can deal with in terms of waivers?
Your Honor,
Or Ms. Rosenwasser, who do we have, madam?
Your Honor, I'm not sure I don't want to miss anybody, but I know that people that I know Mr. Martinez Arnold is here today, and he's one of Mr. Steele's waivers. I know that Mr. Kitchens, of course, is here, and he has his own conflict issue. I know Mr. Stillwell's attorney is here. I'm not sure if Mr. Stillwell is on the platform. I am not.
Let me see if I can find.
My sheet's still low for.
All right. Okay, let me see who, because these folks are not named, let me see who's actually here on the platform. Sir, in S214, sir, what is your name? B11, can you unmute our boxes, our jail Zoom boxes, please, madam?
Yes, Your Honor.
Thank you. I'm sorry, one more time? Cordarius. I heard Cordarius. I didn't hear the last name.
Mr. Dorsey.
He's position 12 on the P&A.
Thank you, madam.
You're welcome.
Mr. Dorsey, good morning, sir.
Good morning, sir.
Sir, we still need to get you a lawyer, okay?
Okay, cool.
Did you have an attorney as of yet? I didn't mean to be so presumptuous, but do you have an attorney, sir, yet?
Not yet, sir.
Okay, all right. I'm going to go ahead and put you back on for the 8th of September, and let's see if we can't find you a lawyer. That was part of the challenge that we're having, and I'll go ahead and see if we can't get somebody appointed to represent you, okay?
Yes, sir.
All right, so I'm going to excuse you at this point in time, and we'll go ahead and bring you back for, on the 8th of September, okay?
Yes, sir.
All right, okay. Thank you much, sir.
Okay, cool.
All right. Violetta, who is, or Mr. Amano, who is in jail, WebEx? Who's that gentleman there?
Let me double check, Your Honor.
That should be Mr. Kitchens.
Is that Mr. Kitchens? All right.
Come on up, Your Honor.
Yeah, sure. If that's Mr. Kitchens, I think we have, Mr. Kitchens, is that you, sir?
Yes, Your Honor.
Okay, thank you, sir. Hold on one second.
Show you. Okay. John.
Let me see if there's anybody else before I go ahead and do that. Mr. Garland, just give me 1 second. Who is in N's 506, Violetta? Mr. Mon, if it's okay, you can unmute the other folks in the other booths. Let me just see who they are, so maybe we can I can take those folks up as well. We have the South Annex, and then we have S714 as well.
Yes, Your Honor.
Okay, thank you, ma'am. And then I think you have somebody in S214 and N606. And then the gentleman from the South Annex is now with us. I'm sorry, Sir, in 214, S214. What is your name?
Millen.
One more time?
Millen. It's Millen.
What's your last name, sir? Oh, it's Bailey?
Millen. M-I-L-L-E-N.
Millen. Oh, okay, sir. Yeah, you're...
Yes.
Also, do you have an attorney, sir?
No.
Okay. Sir, I'm going to reset you for the 8th of September. We'll see if we can get you counsel appointed, okay? All right, because we don't have an attorney for you as of yet, but we'll go ahead and see if we can't work on that, all right?
All right.
All right, but I'll excuse you at this point in time, okay?
Okay.
Thank you, sir. All right, gentleman in N606, what is your name? One more time?
Farley. Miles Farley.
Can I ask you to state your name one more time for me, please, sir, in N606?
Miles Farley.
Miles is your first name?
Yes, sir.
Okay, and what's your last name?
Farley.
Position 3 on P&A, sir.
Thank you, madam.
You're welcome.
And good morning again, Your Honor. Mr. Menendez on behalf of Mr. Farley. I'm just going through the security right now. Would you please hold for me?
Yeah, I can hold for you, okay?
All right, thank you, Judge.
Okay, is Mr. Let's see, Antonio Sledge?
Yes.
You're an N6, yeah, okay, thank you, Mr. Sledge. Do you have an attorney as of yet?
Mr. David Wright.
I'm sorry?
Mr. David Wright.
You hired Derek Wright?
Yes.
When did you hire him, sir?
Probably like 2-3 weeks ago.
Okay, all right. One more time?
Supposed to notice the court that he was going to be my attorney.
Your Honor, Mr. Sledge attorney called in and he said he is on medical leave.
Okay, all right. Mr. Sledge, we're going to set your case over for the 8th of September, okay? And we'll see if your attorney, he's got a medical issue, so we'll see if we can't get you over at that point in time, okay?
Yes, sir.
All right, so he'll be back in touch with you, and so will we. I'll release you for the time being, okay?
Yes.
All right, thank you, sir. All right, gentlemen in S714, what's your name?
Your Honor, that's going to be my case. Carrington Matthews, we're on standby waiting for Your Honor.
6, Judge.
Thank you, sir. All right, Mr. Matthews, thank you for your patience with us this morning. Sir, do you wish to go ahead and waive formal arraignment, have the court enter a not guilty plea on behalf of your client, and otherwise for you to have 10 days from upon the receipt of discovery to file any motion, sir?
Yes, Your Honor, that is correct. And I would ask that we be placed on the September 8th calendar.
For bond?
Yes, Your Honor.
Have you filed a bond motion as of yet?
I have not, Your Honor.
Okay, go ahead and do so. I'll put you on for that calendar for that 8 September calendar for bond. And
Your Honor, I anticipate.
I'm sorry. Go ahead.
Yes, Your Honor. I anticipate possibly another motion that may accompany that as well.
All right, I'll have to determine. Well, when you file it, we'll determine whether or not we're going to hear it on the 8th. Okay.
We'll provide a copy to the court.
All right, okay. E-file it and then send a copy to Mr. Chamberlain and Mr. Kearns, okay?
Will do, Judge.
All right, and your trial will be set for the 9th of January of 2023, okay? That's your trial date.
Got it, Judge.
Okay, all right. Unless you have anything else, sir, thank you for your patience, and I'll otherwise excuse you, okay?
Thank you, Judge.
All right, thank you. Mr. Hewer, you can be released. You can go ahead and go back now at this point in time. Thank you, sir.
All right, thank you.
All right. Okay, let's see. Who do we have at the South Annex? Let's see.
Your Honor.
I'm sorry, one more time?
Ms. Seaborn.
Ms. Seaborn, hold on.
Number 5.
Hold on. Okay, Mr. Theory, you still with us?
Yes, Your Honor.
Okay, thank you for your patience. All right. Okay, I have Ms. Reed and I have Ms. Seaborn and I have you now at this point in time. Sir, do you wish to go ahead and waive formal arraignment and otherwise have 10 days to file motions and have the court enter a not guilty plea on behalf of your client? Or is this a bond hearing for you?
Yes, it's a bond hearing, Your Honor.
Yeah, because I think you all are on for the September 26th calendar. Is that right? trial counter, is that correct?
Yes, sir. Yes,
Okay,
sir.
all right, well, all right. Sir, go ahead and state the Iowa factors you wish me to consider for bond, and I'll let the state respond, Ms. Reed, and then I'll make a decision, okay?
Okay, Your Honor, thank you. Your Honor, this case was on for June 14th, 2022 bond hearing. However, Ms. Sebron was in quarantine, so was further notice to this date. We'd ask the court to consider the fact that my client is 26 years old. I don't believe that she has a felony history, but have to defer to the state. She has community contacts here, Your Honor, is from Georgia. She's 26 years old and has 2 children. She had been working at Clorox prior to her incarceration. She has a high school diploma and she is landscape certified, as well as having a forklift license, and has a OSHA OSHA 10, which means that she can operate forklifts and heavy machinery. Prior to her arrest, she had been accepted into Atlanta Technical College. Your Honor, my client's been in jail since December 10th, 2021. In court today on her behalf is her mother and her sister, her mother Yolanda Sebron, and her sister Rosa Enriguez, Enriguez. On the platform today on her behalf is her sister Shakita Clark and her brother James Sebron. Your Honor, these charges arise from her activities in dealing with the co-defendant, Mr. Thayer, in which our allegation that she was a victim, as much as the alleged victim in this case, who I will call JB, because she is a minor. We would submit that she did not share in any proceeds dealing with the sexual servitude of that child, and was actually trafficked by the co-defendant, Mr. Thayer. We don't believe that she has any histories of failure here. We don't believe that she's a danger to try to intimidate any witnesses or the alleged victim in this case, Your Honor, as she has no history of failing to appear from my understanding. And we believe she will come to court and she will reside with her mother if she is given a reasonable bond. If the court will consider, she will be amenable to house arrest except for work or school and an ankle monitor. We would ask the court to consider bonds of $15,000 for each trafficking a person for sexual servitude charge, which there are 3, and a $10,000 bond for the cruelty to the children charge. We would ask the court to consider a reasonable bond in this matter due to her relatively lack of criminal history. She does not know where this victim is located and will not try to seek her out. And she will be fine with not communicating with Mr. Thayer. Your Honor, she does have a child with the co-defendant Thayer. However, he's incarcerated and she would not contact him if given a bond. He has 2 children, Your Honor. We ask the court to consider a bond in this matter, as I don't believe she has a prior record. She will come to court. Her mother has been steadily in communication with me regarding her daughter, and she has a strong family support system. We would ask the court to consider a reasonable bond under these circumstances.
Okay, Ms. Reeves?
Thank you, Your Honor. This case was indicted on January 13th of 2022. Her original request for bond was denied at first appearance based on the severity and the nature of the crime. That judge found she was a danger to the community, and the state is here asking for you to deny her request today, this is her first request in Superior Court. Attorney Theory is correct. She does not have any prior convictions. However, she is facing 3 counts of trafficking, which carry a maximum of 3 life sentences and 20 years for the cruelty to children charge. In light of that, the state feels that she poses a significant risk of fleeing prior to
My apologies. I'm sorry. You guys, we lost South and the officer just called. The internet's been going in and out. She's not on. So they're trying to log back in now.
Oh, we're going to have to let him back in. Miss Reeves will have to stand fast on that one, okay?
Thank you, Your Honor. I'll be ready.
All right. Yeah, she sure is. All right, we'll pick that up in just a second. Is there Rodalis Ryan on the platform? Mr. Ryan? A Rodalis Ryan, anyone?
Honor to our knowledge, he's in DOC, convicted last fall for a murder charge.
Do you have a
We're going to send an email to the court of everybody that's not in Fulton County in custody after the hearing today.
if you provide that to Mr. Chamberlain?
I will, sir.
Okay, yeah, because and we'll see if we can't get him on for the 8th of September. That would be position number 8.
Yes, sir. Ryan's continued, Judge?
I'm sorry, sir?
Ryan is going to be continued, Judge?
Yeah, I'll continue Mr. Ryan until the 8th of September. Yes, sir. How about Javoris Bradford?
He's not in custody.
He has not been arrested as of yet. Okay. Thank you. What about Justin Cobb? Position number 11?
Cobb's not in custody yet, Judge.
Not in custody either. All right. We'll continue that to the 8th of September as well, just in case.
He's not in custody and he's not in the Department of Corrections.
Mr. Cobb, that's correct, Judge. He's on parole, so he's out right now.
So at this point, there's already a grand jury warrant. We do not need to reset him.
Okay. I'm just trying to keep them all together, Mr. Chamberlain. Just trying to keep them all together, that's all. Okay. What about number 15, Mr. Fleetwood?
Mr. Fleetwood is also DOC judge.
We need a location and identifier for him, and we can put him on. Thank you, sir. We'll put that on for the 8th of September, okay? All right. Okay. Okay, what about Jaden Myrick? Is that Mr. Theory? Are you representing Mr. Myrick?
Yes, I am, Your Honor.
Is Mr. Myrick on the platform?
I don't see him. Mr. Meyer, can you raise your hand? I do not see him on the platform, Your Honor. He will be in 7 South, 113.
I'll have to get Lieutenant Dooley to see if we can find him.
My apologies. What position is Mr. Myrick, sir?
Number 14, madam. He's supposed to be in 7 South 113. I can wait on him.
Received. I actually just called the floor for him a moment ago after Mr. Huey left the booth. So I'll call again.
That's okay. We'll wait. That's fine. Okay. That's fine. Is 6 South, is the South Annex rejoined us? Yeah, I see them. Okay, all right. Okay, let's see. Let's go back to. Okay, Ms. Sebring, what was the last thing you heard, madam?
Sir?
Can you come up to the microphone just a little bit for me, please, madam? What was the last thing that you heard before you dropped off?
My attorney was talking. He was saying something about my two children.
Okay, all right. Okay, Mr. Theory?
Yes, Your Honor.
All right, we'll pick up from there again since she didn't hear that. So go ahead and if you'll continue with, I think the last thing she heard was the 3 children. So if you want to restart your argument from there, and I'll let Ms. Reeves go ahead and start over again as well.
Okay, Your Honor. Yes, in court today, or have been earlier, was her mother, Yolanda Sebring. Please raise your hand if you can hear me, ma'am. Along with her sister, Rosa Enriquez. And on the platform is Mr. James Sebring and her brother and Ms. Sebring's sister, Shakita Clark, is on the platform. She has community connections, Your Honor, and no record. She will come to court when called upon. We'd ask the court to consider bonds of $15,000 each for each trafficking for sexual servitude charge, and a $10,000 bond for the first-degree cruelty to the children. She will be able to stay away from the co-defendant and have no contact with him, and will not try to intimidate any witnesses in this case, including the victim, Ms. J.B., who was a minor child. She has, with her history, her lack of history, criminal history, Your Honor, her lack of failure to appears, we'd ask the court to consider a reasonable bond in this situation. We'd ask the court to consider ankle monitoring services, and that she be on 24-hour curfew except for work and or school. As she had been attending Atlanta Metropolitan, was supposed to attend Atlanta Metropolitan College prior to her arrest. We'd ask the court to consider a reasonable bond under the circumstances that she's not a danger to flee the jurisdiction with the 2 minor children and her community contacts.
If she's released, where's she gonna live, sir?
She would live with her mother in Fulton County, and I can provide that information to the court.
Okay, all right. Anything else, sir?
No, not at this time.
Okay, Ms. Reeves.
Thank you, Your Honor. Just because Ms. Sebring did not hear, I'll repeat everything.
Your camera's off. Ms. Reeves, your camera's off.
I apologize, Your Honor. It's saying the camera cannot restart. Would Your Honor mind if I just leave that off until it decides to turn itself back on?
All right, that's fine.
I think we're all having some technical difficulties, Your Honor. Can you hear me okay, though?
Ma'am, we can hear you. That's fine.
Okay. Her original request for bond was denied at first appearance. Based on the severity of the charges, the judge found that she was a danger to the community, and the state agrees with that. This is her first request in Superior Court for a bond. It's the state's opinion she is not a good candidate. Attorney Theory is correct that as far as her criminal history, she does not have any prior convictions. However, she is facing 3 counts of trafficking, which carry a maximum of 3 life sentences and 20 years for cruelty to children. In light of that, the state feels that she poses a significant risk of fleeing prior to the trial in this case. In order to support why we feel she poses a significant danger to the community, I'll provide the court with a brief summary of the facts in this case. This involves the trafficking of a 14-year-old victim who had been reported missing at the time. The defendant, along with her co-defendant, preyed on that child's vulnerability since she had nowhere to go and exploited her for their financial gain. The defendant trafficked this child for several days out of a room at the Motel 6 in Union City. The child was forensically interviewed, and digital evidence was collected as part of the investigation, including data from the defendant's phones and social media. The defendants posted advertisements of the child on escort websites, which advertised her for sex in exchange for money, and both defendants were positively identified. as the ones who sold her for sex. This defendant, Ms. Sebren, would remain in the room when those sexual transactions occurred in order to collect the money from the child. She had to abide by certain rules, that being the child had to abide by certain rules of the defendants, which included not leaving or not speaking to anyone. The child did not have a phone of her own, and she was not even allowed to take a shower without their permission. Defendant Sebren gave an interview to law enforcement upon her arrest, where she corroborated much of the victim's disclosure and made several other admissions, such as the victim did look like a young girl, admitted that the victim stayed in their room and was engaging in sexual transactions. She admitted to taking pictures of the victim while the victim was wearing lingerie, admitted to writing the ads, which are the descriptions for the victim, admitted that she would go into the bathroom while the victim engaged in those transactions and would even bring her small child in the bathroom with her to wait. What's even more disturbing to the state, Your Honor, is the defendant also admitted that they had done this before with other females, and at least one of those females has been identified by our investigators as being another underage child. As to the victim argument that Attorney Theory brought up, based on our review of the social media evidence, it appears that both parties were very willing in this scheme as a way to make money. But again, that is more of an argument for trial, but since it was brought up today, that discovery has been turned over to defense counsel, and we are of the opinion that she was very much a willing party. In light of everything in this case, the state feels strongly she poses a significant threat or danger to the community and poses significant risk of intimidating witnesses and victims. And based on what she is facing if convicted, that we feel that she may be at risk of flight. And even based on her own admissions, the state's likely to find other victims of this defendant, at which point she will likely face more charges. In light of everything, we do ask that the court deny her request for bond today.
Ms. Reeves, do you have any specific evidence on the Ayala factors that you can tell the court about flight, threats? I mean, I noticed that she's facing significant time, but she's presumed to be not. I mean, presumption of innocence still follows her at this point in time. So, and then has she threatened any witnesses up to this point in time?
No, Your Honor, she does not have a criminal history. Attorney Theory is correct. She does not have any FTAs. We would mostly rely on the threat or danger to the community. And if there are other victims out there that we have not discovered or are in the process of discovering, we do have concerns that she would fear. She's
been in custody a year though, right?
She was arrested December 10th of 2021.
2021, so she's been in custody almost 8.5 months?
Yes, Your Honor.
Has your investigation revealed any such evidence that, or part of discovery thus far?
I'm sorry, repeat that, Your Honor.
Has your investigation revealed any additional victims at this point in time?
Yes, we have, Your Honor.
You have?
Yes, Judge. The one in her interview.
Oh, the one you told me about. Okay. But other than that other one, is there anybody else that you've been able to your investigations revealed?
Not to my knowledge, Your Honor.
Okay.
There was others that she mentioned as far as names that she knew them by in her interview. So we are always diligently work to locate them, but we have confirmed that one of them was an underage child.
Your Honor, we just ask the court to know that interviews were done on February.
I can't hear you, sir.
I would ask the court to consider the fact that these interviews that were done with my client were done in February 26th or so of this year, and that now, almost 6 months later, there have been no additional charges filed against my client who cooperated with the authorities. And she will be able to stay away from social media as well as a condition of a bond if the court will grant her a bond.
Okay. Mr. Theory and Ms. Reeves, given what's been proffered and considering the factors under 17-6-1E and Ayala versus the state at 262 Georgia, I am going to go ahead and set Ms. Sebring a bond. I'll set $15,000 on each count of trafficking a person for sexual servitude and $15,000 on cruelty to children first degree. That total bond being $60,000 cash, property, or security. She will be required to have an ankle monitor that'll be provided by Fulton County. She'll be subject to pretrial level 3. No internet, no social media. She will only be able to go from. She will otherwise remain at home and living with her mother. At her mother's address, only home to attorney, home to doctor, and that's it. No interaction with minors under the age of 18, and only supervised visitation with her own biological children. That'll be the conditions of bond. Ms. Reeves, have I missed anything?
No, Your Honor.
Okay, so that's the conditions of bond, Mr. Theory. Do I need to repeat those again?
No, Your Honor. So I can.
What's the address she's going to live at? Tell me that, because we'll need to know that for the bond.
Can I do the chat through chat with Ms. Umana or is Mr. Chamberlain on? I can send that through the chat right now, Your Honor.
Tell him I'm not on chat. He can send it to me.
You can email that to him, okay?
Okay. I'll be emailing it right now, Your Honor.
Okay. All right. Ms. Sebring, those will be the conditions of your bond. Do you understand those, madam? If you should make bond, that you can't have any social media, no internet, no contact with any minors under the age of 18. You're going to have supervised visitation with your own children. You'll be subject to an ankle monitor. The county will pay for the ankle monitor, but you'll have to come up with a cash, property, or surety to bond out of the $60,000, so you can work with your family on that. And the only places you'll be able to go are home to your attorney, home to doctor. That's it.
I understand, Your Honor.
All right. Okay, then that'll be the order of the court. Good luck to you, madam. And your trial date is set for September the 26th of this year. So in the event that you make bond or you're still in custody, we'll see you on that day, okay?
Thank you.
Yeah, Mr. Theory, you have to put her mother's name and address, full address, on that particular email, okay?
Yolanda Sebring, she was in the courtroom, Your Honor. She can raise her hand, and I am emailing.
Yeah, she's here. She's in the courtroom. I see her, but you'll need to email that to Mr. Chamberlain, okay?
I am emailing it as we speak.
Madam.
I apologize. Your Honor, just for clarity, did you also order no contact with the victim?
Yes, I thank you, madam. No contact with the victims in this case. Ms. Sebring, you understand that, right?
Yes, I understand.
And
Okay.
co-defendant?
Yes, I understand.
All right. And that means your family as well, okay?
Yes, sir.
Okay, all right. Unless there's anything else, then that'll be the order of the court, okay?
Thank you.
All right, good luck.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. May I be excused?
Yes, ma'am, you certainly may, and thank you all for your patience.
Thank you.
All right, let me go back to, I was just, let's see. Okay, Mr. Geary, Mr. Smith, just for your situational awareness, I believe for number 15 on the plea and arraignment calendar, Mr. Garlington, he'll appear at 2 p.m. Yes, because of the notes. Okay, all right, wonderful. All right. Okay, Antonio Sumlin. Is Mr. Sumlin been, or is he on the platform? Let's see. Do we have any updates on Mr. Sumlin, Mr. Geary, or?
He is either in Cobb County, and he is an attorney, I'm sorry,
That's okay.
attorney, I think it's RAGAS, has filed an entry of appearance.
One more time, what's his last name?
RAGAS. Arthur Regas.
Arnold.
Arnold, I'm sorry. Has filed a entry of appearance, I think it was just last week.
Okay.
But I believe, my last information is if he's not been brought to Rice, that Mr. Sullivan is still in the Cobb County Jail.
If we could, if you have any identification, custodial identification for him, we'll go ahead and put him on the 8th of September, and we'll see if we can reach out to Mr. Ragus. Is it R-A-G-U-S?
R-A-G-A-S. R-A-G-A-S.
Okay. First name Arnold. Okay. All right. Okay. Quamarvius Nichols.
No attorney is yet, to our knowledge, Judge. He should be in Rice Street.
Yeah, Mr. Nichols, are you on the platform? Let's see. Lieutenant Dooley, do we have Mr. Nichols on the plan or availability? Quamarvius, I should say. Nichols, he's supposed to be in 5N 613. Okay, we're going to hold that one for location, and I think that.
What happened with position 12?
I'm sorry?
What happened with position 12? Mr. Dorsey, he's supposed to be on photo from the cab. I didn't hear the announcement.
He was continued, Judge.
He doesn't have an attorney, so I'm going to put him on for the 8th, Mr. Chamberlain.
Judge, on position 9, Mr. McCollum, he should be at Rice State, but we showed him with no attorney.
I believe that, yeah, Mr. Mullen, I think we took care of already. McMullen, yes, we took care of him already. I spoke to him, and we're going to put him on for the 8th of September, see if we can get him on an attorney.
Now, was he was on Zoom?
Yes. Yeah, I took care of it already. Okay.
At position 3, Mr. Farley, are we still holding for him?
I'm here for that, Your Honor.
Mr. Farley?
Yes, sir.
Okay, all right. Come on up, Mr. Mateus.
And Your Honor, I'll have one witness. She's logged in now with her audio and video muted. It's Miss Patricia Ford.
Miss Patricia who?
Ford, Your Honor, F-O-R-D.
I'm trying to see if I can find her.
Judge, can we put something on the record, please?
Hold on one second. Let me see if I can find her to begin with, okay?
Your Honor, her box is next to Mr. Farley's, actually, coincidentally.
I'm going to move her.
To the right.
Now I see her. Okay. Ms. Ford, can you turn your camera on for me, please, madam? Okay. Mr. Geary, you want to say something, sir?
Yes, sir. I just want to put on the record, Judge. We were told this bond hearing would not be on the calendar. We would announce not ready. We will follow the court's instructions.
Your Honor, this was on the calendar that was mailed out to us, and it says on there, motion to reconsider bond.
Mr. Geary, I'm going to go forward and it's a motion to reconsider bond. So tell me what's changed since the last time that I considered bond for you, or for your client, I should say.
Yes, thank you, Your Honor, for the opportunity. There's a lot that's changed.
Because I denied him bond back in May the 23rd of this year.
That's correct, Your Honor. That's right.
All right.
That was all based on proffers made by the state and the defense before discovery had ever been sent out. And so, Your Honor, I do want to correct several misstatements that the state made about Mr. Farley at that prior hearing, so that the court now has a more nuanced, full picture of things to take into consideration with the other things presented, as well as the Ayala factors, Your Honor. There was a lot of proffers about the murder count that Mr. Farley is alleged to be a party to. We've since gotten the discovery. The warrant affidavit itself alleges no party to a crime allegation whatsoever. It alleges just mere presence and mere association, Judge. And I've now done a little investigation into Mr. Farley's clothing company, which is what brought him into all this in the first place, Judge. And so I do want the court to consider that together with some proffers. And I understand the state's position about the privacy of the discovery and that they have a pending motion about us not sharing discovery outside of our legal staff. And I would also, for the record, they have made some implications about the defense counsels in this case, yet they're using Dropbox, which is a private third-party company. So it's entirely possible that someone within their office or someone within Dropbox has connections to social media and, TMZ and stuff like that. So I would ask, Judge, if we could do an in-camera inspection of some very small portions of the discovery, specifically the BP video that the state referenced earlier at the prior bond hearing.
Did you put that in your motion?
No, Judge, I didn't.
Okay, so I'm going to take up that on the 8th. So if you want to proffer or have me consider that, file a motion. And I invite you to put some suitable facts and law in there like you're doing right now, and have me consider it and have the state respond to it, okay?
Yes, Judge, and may I continue?
Yes, you may. Go ahead.
Yes, so in the case that bond is denied today, Judge, I will return on the 8th with that in-camera motion. But for now, Judge, I'll proffer what I find different to the state, Judge. For one, the state implied at the prior hearing that Mr. Farley knew these people very intimately, that he greeted them when they walked into the BP. But, Your Honor, what actually happened is there's a Fusion and an Audi. The Audi is alleged to have Mr. Shannon Stillwell in it. The Fusion is alleged to have Mr. Quamarvius Nichols and Mr. Farley in the back seat with Quamarvius driving. And so the Audi and the Fusion are at this gas station right around from the juvenile court, Your Honor. And then the deceased pulls up in a car. And when that deceased leaves, the Audi follows him and the Fusion follows him with Miles in the back seat of the Fusion. The license plate readers confirm that the Audi is in front of the car that Mr. Miles Farley is in the back seat of. And Your Honor, it's this mere association with Mr. Quamarvius that led him to be there. He's not even a driver of one of the cars. And he doesn't actually greet anyone when he walks into the BP. Mr. Stillwell and Mr. Nichols are standing at the cashier, doing something playful with the cashier. And Mr. Farley later gets out of his car from the back seat, walks into the store by himself, and doesn't acknowledge Mr. Stillwell or Mr. Nichols. And as he's walking by to get something, Mr. Stillwell turns and does this playful, bucking kind of playful thing and startles Mr. Farley, who then playfully turns around and continues to go into the store. And then out of the corner of Mr. Farley's eye, he sees Mr. Stillwell and Mr. Nichols about to just leave him there. And so he, in a panic, scurries away, follows them out the door. They don't even acknowledge him any further. They turn his back on him and they leave, Your Honor. So the association and the presence here has more nuance to it than the state alleged at their proffer, Judge. And so what I contend to this court is its corroboration of what I presented to the court initially, that Mr. Farley, he's a graduate of South Atlanta High School and Miles University, and all this time at 24 years old, has never been convicted of anything besides a misdemeanor amount of marijuana at some point, Judge, which is a typical teenager, childish thing. So, Your Honor, he has no criminal history. He's an entrepreneur with a business degree, and his specialty is he makes clothing. The company is called Make America Slime Again. It's a play on words. In the hip-hop industry, there's a lot of this. You put the word trap or slime into something that's already part of pop culture. It's just good business, Judge. It's something people already recognize. It's something that's kind of humorous, and this is one of the shirts, Judge, I have for you to see. This was a new shirt after Make America Slime Again off of the Trump logo or slogan. Now there was Keep America Slime. So all it is, Judge, is these hats and shirts that took the Trump merchandise, replaced it with this word slime, which is not always criminal. And like every word, and especially that word, it's context dependent. It's like the word dude. It depends who's saying it, when are they saying it, who are they saying it to, why. You could be my dude, you could step on my shoes, and I could be like, dude, what was that? You could be that dude. There's so many things. So slime on its own means nothing because it can mean so many things depending on the context. So that's all he's doing, Judge. He's making these clothes. He sees a business opportunity. He's friends with Mr. Wunny Lee, who's the creator of the hip-hop persona Slime Life Shorty. And as his friend, he becomes his personal assistant to make sure he gets to music videos on time, stuff like that. He's actually paid by the label that's not even YSL. And then, Judge, he's using the proximity to celebrity to take advantage of just attention, which is a top commodity these days, name recognition, product placement, to have his hoodies and his shirts in these music videos worn by these artists is a way to make money. And he's born and actually raised on Cleveland. It's not just a tattoo. He's raised on Cleveland Avenue. His dad's also an entrepreneur. They call that area Little Haiti because there's not a lot around, so you have to be an entrepreneur. So here we have a young man, college educated, never been arrested for a felony, and he's making his clothes, and instead of sitting there and maybe, selling them on the street next to the people, doing the lamb chops or selling the Powerades, he has this brilliant idea to go on tour with Mr. Wunny Lee and sell to fish in a barrel these suburban kids that go to these concerts. And I can proffer, Judge, as an officer to the court, I remember what that environment was like, back in 2008, going to University of Michigan, go to the Kid Cudi concert, buy the t-shirt, and I almost want to say that I do remember there was a shirt where they had Kid Cudi as the Obama campaign thing at the time. So similar to what's going on here, Judge. It's like a deja vu. And so I admire Mr. Farley. He's very smart. He's well educated, and he found an opportunity to make this clothing. And then the state, because he's wearing this shirt that says slime or die, again, a play on words, if Your Honor remembers the Get Out the Vote campaign, Vote or Die. I think it might have been P. Diddy or some people at the time were pushing that. Again, Judge, just our artistic play on words, proximity to other artists who are in music instead of clothing, and that's all this is, Judge. So on the Ayala factors, He hasn't ever threatened to tamper with any witnesses whatsoever. He's barely in any of the discovery. This 5 terabytes, it's not even everything, but he's barely in it, Judge. He pops up on the scene because he returns home after going to college instead of going out of state. And, you know, I admire him for that. He's a family-oriented person. He has a child. The mother of his child helps him with the clothing company, Your Honor. And his father still stays there in the barbershop on Cleveland Avenue. And so I just don't see now, with having the discovery and knowing more about the clothing line, how we can deny Mr. Farley's bond. He can't be considered any risk, let alone a significant risk of reoffending, because he's never even been accused of a felony besides this. And the warrant affidavit itself, to this day, along with the discovery, alleges no assistance or any of the other 5 ways that you can commit a party to a crime, in addition to being the principal. It does not say that. It just says that he was driven somewhere by Comarvius, gets out of the back seat, gets back in the back seat, and then the car is behind a car that's alleged to be involved in a shooting, and we don't even know the circumstances of that shooting. It doesn't even seem planned. It doesn't seem to be connected to anyone the way the other murders are alleged to be connected, Judge. And so he can't be considered a significant risk to reoffend. He can't be considered a danger to the community. He's college educated with no criminal history. He can't be considered a flight risk. He's cooperative the entire time. He is arrested without incident, without flight, no attempts of flight. He's had his communications monitored this entire time. I know that the Fulton Jail even has voice recognition that knows when people are using other people's phones. He's not anything like that either. And so, Your Honor, the state does allege that he's present at a public forum, a public hearing with Mr. Wani Lee at some point. But again, Judge, he's his personal assistant. And all that the discovery alleges is that Mr. Farley told him where the courtroom was. There's no threatening. There's no witness intimidation, Judge. His communication has been monitored this entire time at the jail. And he just can't be considered a risk for any of the IL factors. And so, Your Honor, we just asked for their bond to be set in a reasonable amount, given the severity of the charges, to add some harsh conditions. I propose for the court a bond of $100,000, that he stay at the address that we provided to the court at the prior hearing, 2894 Browns Mill Road in Atlanta, Georgia, zip code 30354, and that we put him under the highest pretrial level of supervision and a 24/7 house arrest, and even take away his internet access. He can conduct his business through assistance without having to actually access the internet himself, Judge. That way, there can't be any worry about him contacting any witnesses or anything like that. And so, Judge, I do want to call Miss Patricia Ford very briefly to say a few words about Miles. She's his high school principal. She knows him very intimately over several years, and she can speak as well to the IL factors, Your Honor. So I would want to briefly call her and then allow the state to respond.
All right, Ms. Ford, can you unmute yourself, please? Ms. Ford, can you unmute yourself, please?
Yes, good afternoon.
Madam, can you hear me?
Yes, I can.
You're gonna have to speak up just a little bit. I'm gonna administer an oath to you, okay?
Okay, that's
Can you
fine.
raise your right hand for me, please? You solemnly swear or affirm the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God or so affirm?
Yes, I do.
Okay, you can put your hand down, and you have to speak up. Use your outside voice.
So my name is Patricia Ford. I was Miles' principal for 4 years. Miles, he was my student. He was like my son. Everyone knew Miles was my student. And if Miles didn't do his homework or he just didn't do anything on task academically, they would bring Miles to me and I would just address Miles like he was my child. Everyone knows the love that I have for Miles. He performed well academically. He's a short kid by stature, but just a mighty soul and a mighty person. A lovable young man who went off to do great things after leaving South Atlanta High School. And so as a school, we all know Miles, we love Miles, and have just been taken aback by what he's being accused of just because of his disposition and demeanor, that he portrayed and demonstrated while at South Atlanta. Never got into any trouble while at South Atlanta. He may have gotten into something his senior year for horse playing. He is known for just being a jokester and horse playing at school, but getting into fights never happened at South Atlanta High School. Not in my 4 years of knowing him. Just an overall good kid.
All right, thank you, ma'am. And just to be clear, you were the principal. Was Miles ever accused of any kind of misconduct or suspended from school or anything like that, besides the horseplay that you mentioned?
Nope, not at all.
Okay. And did you stay in touch with Miles after you graduated?
Yes, we did. He would come by the school when he was on vacation from school. He would always talk to another staff member at school, and I would keep up with him through her.
Okay, and as a principal, do you sometimes have a sense when you're observing these students in their formative years, which students might get into trouble in the future and which you feel like, no way, that's going to happen? Okay, and which of those buckets did Mr. Miles Farley fall into? Your discretion as a principal?
This would be the one that would never get in trouble because of his home bringing by his parents. He was just like a good kid, like we would say, just raised the right way. So just knowing that he's caught up in this is just taking many of us aback at the school who are still there and who knows Miles.
All right, thank you, ma'am. And then if he requires any of your assistance while he's being supervised and released on bond, would you be there for him to support?
Absolutely.
All right. Thank you, Ms. Ford. Those are all my questions.
State, have any questions of Ms. Ford? Okay. All right, Ms. Ford, thank you very much. I'm going to put you back on mute. You can be excused to go back to your usual duties and avocation. Okay?
Thank you.
All right. Thank you much, ma'am.
Bye-bye.
Your Honor, that's all I have at this time, except for a brief opportunity to respond to anything that the state might say.
Okay, what says the state? Go ahead, Mr. Geary.
I'll just do it from here.
You can sit or stand, sir, whatever your pleasure. I know we've been here a while, and it's about time for me to take a break, so.
No problem, Judge. Judge, contrary to what counsel just indicated, there is actually nothing new from the bond hearing from the 25-23, Judge. On that date, and what counsel wanted to do was argue the sufficiency of the evidence at trial, which is again not what bond is about. Understand he's presumed innocent, but we have the evidence. We've got the videos. We've got all the evidence there. Further, if we want to talk about the evidence respectfully, Mr. Farley instructed his girlfriend and or baby mother to dispose of a phone and dispose of a gun before we could get there. She didn't. We got it. So that's there. We've got Instagram posts by Mr. Farley basically saying forever homicide. Now, that's not a clothing. That's in line with YSL gang, with other gang members. You know, he's got the tattoos. He can't hang around YSLs and falsely claim. He's got them, the tattoos, and he's hanging with other YSL members. So he's not falsely represented. He's in the video. He wants to say he's Mr. Lee's assistant. He's in the video throwing gang signs, armed with a weapon. I'm not sure if that's in his job description as an assistant. He is seen numerous times on Cleveland. They say he's raised on Cleveland. Raised on Cleveland is the name of the predecessor gang to YSL. That is a street gang. And people want to just say, oh, I was raised on Cleveland. That's a gang identifier, Judge. Swear to God, he wouldn't be the first criminal to try to make $1. Judge, the fact that he might have a clothing line on theirs, and I will say that for Mr. Williams also. Mr. Williams has made an interview that stated the gang pre-existed the record label. It pre-existed the clothing line. That's a recorded statement by him. So anything that's marketing after that is an opportunity. I'm not saying they're not taking advantage of that. That doesn't mean they're not committing the original crimes. So just the fact that he is trying to make money off of selling something that is gang related, has got nothing to do whether he would commit offense. And I say this kind of left-handed respectfully. I know counsel didn't make an admission here, but he states the recording does show he's there on the scene at the time of the murder. It does. And it shows a lot more than that, Judge. He characterized the recordings. It's going to be for the jury to determine that. Judge, this is basically the same thing was presented to you on 523. You found there's no reason, there's no evidence presented to change that ruling, Judge. We ask you to deny.
Okay, all right.
Yes, Your Honor.
You got a minute?
Yes, just a minute, Judge. I agree with a lot of what the state said. Yeah, making a clothing line and using artistic content doesn't connect you to crime and make you a criminal. Just like wearing a Scarface shirt or a Godfather shirt doesn't make you part of the mafia. It's art. What Mr. Williams is making is art. It's spread all over the world, and now Mr. Farley is a bystander, Judge. What the state didn't correct was that, yeah, he's on the BP video, not doing the things that the state proffered he was doing at the original bond hearing, Your Honor. We didn't have any of the discovery at that time. And this hashtag YSL, I mean, the word slime isn't even originated in Atlanta, Your Honor, as far as I know. I went around on the internet a little bit. There's a mixtape by VOD up in New York in 2009. It's called Slime Flu 2. And that predates a lot of this. So I think they're trying to just take advantage of this cultural term. Again, slime or die. It's just a play on words from vote or die, Your Honor. And it has nothing to do with whether or not someone's committed a crime. That's done through evidence. And the state still has not proffered anything beyond mere presence and mere association. The Forever Homicide, Your Honor, that's a song by Mr. Wani Lee, performed by the character Slime Life Shorty, where it's a play on words of homicide and homicide. I'm always by my homie's side, and it's just a little play on words with the word homicide. Mr. Farley, you heard from his principal, has never even been violent at school. Gang behavior begins sometimes at 12 years old, 13 years old. This is so out of the ordinary as an allegation. Who joins a gang when they're 24 years old and never even got in a fight at school, and yet they're a homicidal person that can't even get a bond when they're presumed innocent? So, Your Honor, this YSL has been hashtagged over 21 million times all time in Instagram. And so because Mr. Farley has a page that also has T.I. and Future on it, wearing his hats in addition to Mr. Williams, it's just not, there's still nothing now that we have the discovery, and now we also have an actual live witness, Ms. Ford, to correct the misstatements of the state in the prior bond hearing. And it's clear now that Mr. Farley is not a significant risk in any of the IL factors, and there are ways to mitigate these baseless allegations of witness tampering that he has nothing to do with and has been reported all this time. And if they have his phones and they have these incriminating things, and yet that's all they can still proffer, Your Honor, he definitely deserves a bond. It's just the conditions are at issue now, and we're willing to submit to any conditions from this court whatsoever, Your Honor.
All right, thank you, sir. All right, Mr. Menendez and Mr. Geary and Mr. Farley. I've had an opportunity to reconsider the what has been proffered in this particular from the 523 hearing in this case. Mr. Menendez, I don't find any change in circumstances. I do agree with the state in this particular situation. At a minimum, your client still poses a threat to persons and property in the community and poses a threat to intimidate witnesses or otherwise obstruct administration of justice. So I'm going to deny bond at this point in time. He's still on trial for the 9th of January of 2023. And if you file any other motions, let me know, and we'll go ahead and hear those expeditiously, okay?
All right. Thank you, Your Honor. Good to see you.
Can we arraign him since we've got counsel?
Yes. Mr. Farley and Mr. Menendez, since you are here and the new indictment has in fact come out, Mr. Menendez, would you like to go ahead and have me arraign your client on the re-indictment?
Yes, Your Honor, that's fine. I went ahead and filed a packet of consolidated motions. Okay. And all I can think of now is that in light of the bond denial, I do intend to join in Mr. Steele's speedy trial motion.
We'll file it, and we will move on it accordingly. But in terms of the indictment, 22 SC 7-2, is it your desire to waive formal arraignment on behalf of your client?
Yes, Your
Otherwise,
Honor.
have the court enter a not guilty plea on behalf of your client, and for you to have at least 10 days upon the receipt of discovery to file any motions?
Yes, Judge, we waive formal arraignment, plead not guilty, and we would ask that in light of the massive amount of discovery and the several co-defendants that we be allowed 60 days till after the completion of discovery to particularize or file any.
I'll give you 30.
Okay.
Because I'm still planning on moving on this case on the 9th of January. So, and I believe you've been given some discovery already, correct? So this would just be updated discovery. They just re-indicted to, for other reasons, but I'll give you 30 additional days, okay?
All right, thank you, Judge.
All right. Then, and then it'll remain on the 9 January 2023 calendar, okay?
Understood.
All right, thank you very much, sir.
All right, I'll see you on the 8th.
All right, okay. All right, Mr. Farley, you can be excused at this point in time, sir. Thank you. No, unless he has any other motions that have been filed, no.
Okay. I'll let the court know, Your Honor. I do anticipate filing a motion to sever, but I'll just keep the court updated with.
If you file such motion, let Mr. Chamberlain know, and I'll make a decision as to whether or not I hear it on the 8th or some other date. Okay?
Yes, sir. Thank you.
All right. Thank you, sir. All right, let's see who else we have left. That needs to at least proffer at this point in time. I believe that we have, let's see. Ms. Omana, can you tell me who's in N506?
One moment, Your Honor.
Thank you, madam.
Your Honor, Mr. Garland and I both have an afternoon conflict. If we could do our waiver whenever the court's ready for Mr. Kitchens, that would be helpful.
Madam, I'll go ahead and take that up next, okay?
Thank you, Your Honor. I think he's already on the Zoom.
He is. He is.
Thank you.
Your Honor. Just hang tight, hang tight. And folks, Ms. Nova, Nova, I understand you're eager, but I need to take a comfort break. I've been here since the time we came out, and I'm over 50. Of
course.
And so's Mr. Apt and several other people, Mr. Gary. We would all like to take comfort for just a few minutes. So if we could maybe have 10 minutes, that would be great. I think that would probably be appropriate under the circumstances. So I'm going to take 10 minutes. We'll see who's here at that point in time. I'll go ahead and take Mr. Kitchens up at that point, okay? You can be excused, thank you.
Three favorites. Just reach was
What big do?
I guess maybe we should take 3 seconds. I mean,
It's the third.
I got an adapter. You can plug it in my computer. If you've got the cable, I got
Hey, Juan. Yeah. Good.
Hopefully that works.
Good. Good. You lost a little bit of that, Anna? Wow, 199. Yeah.
Sergio, your audio still is on, by the way.
All right.
And Jeffrey, I don't believe you're muted either. You're not muted.
Yeah, really. Yeah.
He's on that.
Got it. You see, got it one.
Oh, yeah.
Okay, guys, everything y'all are saying is being recorded. Don't talk. Don't even talk to each other. Sergio, not you. Just don't say anything. Sergio, I'll try to come see you tomorrow, or at least do a call tomorrow, okay?
They gotta be your pips.
Christian. Yes. Can you tell my family to rebook their visit?
Hold on, it's hard for me to hear you. Let me, don't say anything. Don't say anything. I just don't want anything you say to be recorded. Because it takes everything you say out of context. So I don't, even if you say it to my family, it's going to be something base, like they're going to talk about later.
Nah, it was about a visit with you.
Huh?
It was about a visit with you.
Oh, okay. Let me I'll do a video call in our house.
Yeah, I was just telling them to reschedule it. Okay.
Okay. Can you see me now?
Yeah, I can see you. I was telling you, just tell my family to rebook the visit behind.
Yeah, go ahead. Yeah, come again.
I let her do it. If you're not counsel, I have you sit outside.
I have the video. I mean, not the video. I have the audio of that guy now. No, I don't have video. I just have audio from my thing. Because he just did like from 0 to 60. Were you guys hitting him or something back there? Getting him under the door. He didn't get tased though. My sister, because my sister is a retired police officer. She's like, tasing him or something. It's all high tension. I said, yeah, he was just being interrupted. Yes, you do. I got a lot of your files. Because, like, I sent it to a few people. So she hated it.
Please remain seated, court come to order.
Please be seated.
All right, I'm going to take up Mr. Kitchens at this point in time, folks, and we'll see who else is on the platform.
Your Honor, since my client's not on the calendar today, may I be excused?
Yes, you may, of course, if you like. And I'll see you on the 8th. You got an in-court notice, and we'll send you out also a formal notice as well. Okay?
Thank you, Your Honor.
All right, you're welcome, sir. Madam, hold on a second. Please. All right, Ms. Novak, I have your client's waiver. I'm going to mark it as court 2. What were you going to tell me?
Actually, I think that's something to add.
Yes, ma'am.
Your Honor, our position, because Mr. Winfrey is not in custody, and that's the only conflict we've identified with Mr. Sadow, once we have, if Mr. Kitchens does decide to go ahead and waive that conflict, we would not have any further concerns about disqualification of Mr. Sadow beyond Mr. Kitchens' waiver, as Mr. Winfrey is not in custody at this time.
Yeah, like I said, I'm not going to deal with Mr. Winfrey today because he's not represented. So, okay, that's fine. Ms. Novak, you still want me to go through the waiver with Mr. Kitchens?
I think we should.
I think we should as well, too. All right, Mr. Kitchens, let's see if we can unmute you. All right, sir, can you hear me?
Yes, Your Honor.
All right, sir, can I get you to raise your right hand for me, please? You solemnly swear or affirm the evidence you'll give in the case now and hearing to be the truth, whole truth, and nothing but the truth, so help you God, so affirm.
Yes, Your Honor.
One more time? Yes?
Yes.
Okay, you can put your hand down. Okay, Mr. Kitchens, I am holding a document which is entitled Conflict Waiver. Okay, I just want to go through that with you briefly, okay?
Yes, sir.
Okay, all right. It starts out with your name. It says, my name is Sergio Kitchens. I'm a defendant in Fulton County Superior Court, case number 22 SC 1822773, which has been re-indicted under 22 SC 183572. Did you have an opportunity to take a look at the both indictments, sir?
Yes, Your Honor.
Okay, all right. And this is a RICO case with 28 defendants, including Mr. Winfrey. We're not going to talk about Mr. Winfrey today, but you do understand that, correct?
Yes, Your Honor.
All right. You're represented by Mr. Sadow, Mr. Samuel, Mr. Garland, and Ms. Nove. Is that your understanding? Is that correct?
Yes, Your Honor.
Okay, all right. And it is your understanding that in late 2015, that Mr. Winfrey hired Mr. Sadow in Cobb County Superior Court case number 15-9-276528 to appeal his case to the Georgia Court of Appeals and then the Georgia Supreme Court. Is that your understanding?
Yes, Your Honor.
All right. And this is in the conflict waiver I'm holding up right here, and it bears your signature on the second page, and the witness is Ms. Nove. This is the document I'm reading from. So did you have an opportunity to take a look at this document and sign this document?
Yes, I did.
It would have been dated the 10th of June of this year. So I'm holding up the documents that's been submitted to the court. So that's the document I'm referring, okay? As Court 2.
Yes, Your Honor.
Okay. All right. The Supreme Court reversed his conviction in Winfrey versus the State 304 Georgia 94, and that's further been cited at 816 Southeast 2nd 456 2018. And then Mr. Sadow then represented Mr. Winfrey in Cobb County, where his offered plea was entered. Is that your understanding?
Yes, Your Honor.
All right. It further goes on, your waiver further goes on to say that Mr. Sadow continued to represent you in this RICO case that's here in Fulton County after and under the 2 indictment numbers that the court has already referenced. So you've spoken to Ms. Nove and discussed the types of potential conflicts that could come up with a lawyer who previously represents a defendant who later represents another defendant in a case in which both are co-defendants. So did you have an opportunity to speak with her to your satisfaction on that issue?
Yes, Your Honor.
Okay, all right. The waiver also further enumerates 6 points. The first one is the state could offer to dismiss the case against one defendant, reduce the charges, or agree to a lower punishment if that co-defendant would testify against the other. You understand that?
Yes, Your Honor.
You also understand, number 2, that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other.
Yes,
She talked with you about that, correct?
Yes.
All right, number 3, the lawyer may want to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client. You understand that?
Yes, Your Honor.
4, during closing argument, the lawyer may want to argue that the evidence against his current client is less than evidence against the former client. You understand that?
Yes, Your Honor.
All right. And then number 5, if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client. You understand that?
Yes, Your Honor.
And then number 6, the lawyer may have learned something from the former client that helps the current client but hurts the former client. You understand that?
Sir, I understand, Your Honor.
All right. So Ms. Nove went over examples of how these potential conflicts might come up in this case. Is that correct with you? Mr. Kitchens, are you there? I froze up, I think. Oh, he's back. Okay. All right, Mr. Kitchens, what was the last? Can you hear me?
Yeah.
What was the last thing you heard me say? I couldn't hear. I can't hear you, sir.
I didn't hear what you said.
All right, let me go over this last part here. The last thing I said was that Ms. Nove, did she go over examples of how these possible conflicts, the ones that I've enumerated in 1 through 6 on your waiver, might come up in this case. Did she talk with you about those? Give you some examples?
Yes, Your Honor.
Okay, all right. Your waiver goes on to say that you understand these potential conflicts. Is that right?
Yes.
Okay, but you are certain that no actual conflict exists, and that no actual conflict will ever exist.
Yes, Your Honor.
And that's your understanding. All right. Is that correct?
Yes, sir. That's correct.
All right. Do you fully understand what Ms. Nove explained to you?
Yes, Your Honor. I fully understand.
Okay. Do you understand you have the right to select a different lawyer?
Yes, Your Honor. I understand.
However, you don't want you don't want a different lawyer. Is that correct?
That's correct.
You want Mr. Sadow to fight for your innocence and freedom. Is that right? That's what it says in the waiver. He's back. Okay. Okay. The last thing I said, sir, was you choose Mr. Sadow to fight for your innocence and freedom. Is that correct?
Yes, Your Honor. That's correct.
All right. And you waive any potential conflict and ask that the court preserve your right to choose a lawyer who you want to protect you. Is that correct?
Yes, that's correct, Your Honor.
And you make this statement voluntarily, knowingly, and freely in the presence of Ms. Nove. Is that correct?
That's correct, Your Honor.
All right, and you declare under the penalty of perjury that the foregoing waiver is true and correct. Is that right? Did you hear the last thing I said, Mr. Kitchens?
Declare.
You heard me? Okay, so you declare under the penalty of perjury that the foregoing waiver is true and correct. Correct? Is that right?
Correct, Your Honor.
Okay,
Yes.
all right. Do you offer this statement freely?
Yes.
Did anyone force, trick, or otherwise cajole you into entering this waiver?
Yes, I heard you, Your Honor.
Let me go through this one more time. Do you offer this statement freely and voluntarily? No one otherwise forced or tricked you or in entering this waiver. Is that correct?
Yes, that's correct, Your Honor.
All right. Okay. All right. Anything else, Ms. Nove or Mr. Geary? I did already.
I missed it. That's my error.
Okay. No problem. No worry. Okay. Anything else? Anything else is in terms of the waiver? Okay. All right. Any questions on behalf of the state or anything that you want me to inquire about?
Nothing from the state, Your Honor. We believe that satisfies any conflict from Mr. Sadow. And should Mr. Winfrey be captured, we would just ask the court to fire him at that time.
Yeah, I'll inquire about Mr. Winfrey when he becomes within the breast of the and jurisdiction of the court. Mr. Kitchens, I'm going to go ahead and let Mr. Sadow continue to represent you, understanding that in the future, if a conflict does arise, you are welcome to raise that to the court, or if I see it, I may raise it on my own motion or depending upon the circumstances in this case, okay? I think you're still frozen.
He tried to say okay. And he froze.
All right, Mr. Kitchens, did you hear the last thing?
Yes, Sean, I heard what you said. Thank you.
Okay, all right. Anything else in regards to Mr. Kitchens? Can we rearrange him? Okay, all right. Okay. Mr. Garland, would you like to otherwise arraign your client on the new indictment, that being 22 SC 183572?
We'd like to address that now when we waive formal arraignment.
Okay, I will authorize for you to waive formal arraignment. I'll enter a not guilty plea on behalf of your client. I'll otherwise give you 10 days upon the receipt of new discovery to file any other additional motions. Do you have any other issues, sir?
If we got 30, Your Honor.
30. Okay, 30. All right, 30.
It's because you like me so much.
Okay, all right, anything else? I got a mask on, thankfully. All right, okay, anything else?
And I think we worked with the state where they've got our hard drive, so we'll get the remainder of the discovery.
Do you have any other motions outstanding that need to be heard on the 8th of September, madam?
Not at this time, Your Honor.
Okay, all right, just want to make sure. All right, okay, all right. Unless you have anything else, then I will excuse Mr. Kitchens and excuse you all, counsels, and thank you for your patience, okay?
Thank you.
All right, okay, cool. All right. Do we have anybody else that's with us today that we can do waivers for at this point?
Your Honor, good afternoon. Nicole Moment to Mr. Greer. He's going to agree on the motions calendar. He was in N506.
Hold on one second. All right, Ms. Mormon, you like to have a bond hearing, is that correct? How come you can't do it now? I got space issues. That's why I'm trying to kind of do this, and it was supposed to be heard today. Okay. Yes, sir. Bond was filed. I get motion for bond was filed on 6/28/22. Mr. Geary.
I don't expect we'll oppose the motion for bond. He's convicted of murder last fall. He had a life sentence. He ain't going nowhere. Respect him.
He was not pending. It's been reversed. He's out of bond on that.
It's been.
Pending.
I'm again wrong. I'm over too.
Hey, you can't be right on everything, Mr. Geary. It's all right. It's okay. All right. So can we do his bond today? Okay. All right. Thank you, madam. All right. Okay, Mr. Greer. Ms. O'Mana, can we unmute N506, please, madam?
Yes, Your Honor.
Okay. Okay, Mr. Greer, can you hear me, sir? Okay, all right. All right, Ms. Mormon, if you'll go ahead and state what IL factors you wish the court to consider and any other relevant facts, I'll let the state respond and hopefully I'll make a decision, okay?
Yes, Your Honor.
All right, go right ahead.
In addressing the AL factors, Mr. Greer is 33 years old. He's a lifelong resident of Fulton County. If released on bond, he will reside in Atlanta with his mother, and the significant amount of his family is here today. He has 3 young children. His entire family is here from Georgia. When he was notified about the outstanding indictment for this case, he was on tour in California. He did immediately jump on his tour bus, come back to Atlanta, and turn himself in. He's not a flight risk whatsoever. As far as a risk to reoffend, he has no prior convictions. As the state has discussed, he was convicted in 2010 of murder. Since that conviction, he did take it up, and it was reversed and remanded back down. He's been out on bond since 2019 for that. But outside of that, no prior convictions. The issue with the intimidation of the victims and witnesses, Mr. Greer is not accused of being in any gang. He doesn't have any tattoos. He hasn't been classified as being a gang member. He's not accused of any violent crimes in this indictment or prior to, aside from the now reversed case. He's not been accused of any direct contact with any victims, any intimidation, any having anybody else intimidate. The state offered that information earlier as well. This is a grand case, as you know, and not only that, there's 2 defendants on this case that are known worldwide with a magnitude of fans. So I don't believe Mr. Greer should be held accountable for any threats, alleged threats. Again, we haven't had any discovery for these allegations of threats. That's kind of out of his hands. Whether he's in custody or outside of custody, Mr. Greer is not accused of intimidating or threatening any victims or witnesses in this case. And as far as danger to the community, again, he's not alleged to be gang affiliated. He has been out on bond since 2019. He had, as far as his time that he did serve in custody, he hasn't had a DR since 2013. He poses no threat. The time that he's been out, he's had no issues until this came up. He did have, I think this, count 13 in this case is the theft or receipt of a firearm. He was arrested for that in 2020. There was no cross. He was charged with possession by a felon. He essentially wasn't a felon, so that charge was no cross. Mr. Greer does meet all of the factors in this case, and we understand that this case is set to go to trial in January. But given that he does meet all the factors, all 4 of the factors, we do ask that a reasonable bond is granted, and we are offering 24-hour home confinement at his mother's residence in Atlanta, and whatever other conditions the court is comfortable with ordering.
Okay. All right, thank you, madam. Yes, Mr. Geary?
A few things. I want to speak here that as part of the council statements correcting and threatening. We actually tried to set up their murder, and that is caught on wire at the jail. He was out on bond after that from 2019. During his stay in prison, he's a documented Goodfellas gang member with extensive gang conduct in jail. He's part of a hybrid gang concept we've spoken to the court about. He's both a good fellow and he's YSL. He is also Mr. Williams' brother. He is on videos, throwing gang signs with weapons. He has the count told you the charges were dropped because he wasn't a convicted felon. Well, the other problem with that we used is the weapon was also stolen. So there's a theft by receiving charge, and that's what's count 13 in this judge. Judge, he is in leadership in that gang, and since he's been in there, Judge, there was not since he's been there, it's before he got arrested, Judge. We had him on a wire talking to people on a contraband cell phone about how to smuggle more cell phones and other illegitimate items into the jail through a window that had been broken. And that, along with an attempt to have someone in the jail murder an individual who threatened a fellow gang member in the jail by someone in the jail, that makes him not only a danger to the community, that actually makes him a danger within the jail. But, Your Honor, he is a danger to commit additional felonies. He's a danger to the community. I can't say that he's a danger to flee. I don't know that to be true. But for the rest of them, I think he's a danger to intimidate witnesses, to the community, and to commit additional crimes, which he has done right up to the point when we arrested him on these charges.
Your Honor,
You may, madam. You can talk.
Your Honor, the state proper information about Mr. Greer being a member of Goodfellas. I'm sure this has come up many times that typically anyone that is from a certain area in Atlanta, when they go down the road, they are identified as Goodfellas. In classifying him as being a Goodfellas, I don't believe that there was anything other than, I don't think there was anything that, aside from where he's located in Atlanta, that was why he was considered a Goodfellas. Also, in being YSL, there's no identifiers other than Mr. Williams being his brother. There's no photos of him with YSL clothes. There's no tattoos. The state alleges gang signs. I haven't come across the gang signs that have been alleged yet. It's just a proffer. As far as Mr. Greer being in a leadership position, the indictment states out very clear the members that they're accused of being in a leadership position, and Mr. Greer is not one of them. He's not charged in any gang counts in this indictment. And for those reasons, Your Honor, I do think he does meet all four AR factors, and I would ask the court to consider a reasonable bond.
Thank you, madam. All right, Ms. Mormon and Mr. Geary, the court's had an opportunity to consider the proffers for a bond in this particular circumstance. I do believe that he poses, he being Mr. Greer, poses a risk of committing additional felonies, and he poses a risk of intimidation of witnesses or obstruction of justice, administration of justice. For those reasons, I'm going to deny him bond at this point in time. Ms. Mormon, if the situation should change, you're welcome to file a motion for the court to change in circumstances or reconsider his bond. I certainly will do that. But at this point in time, I'm going to leave bond. I'm not going to grant bond at this point in time. And do we need to, let's see.
We need a waiver and a waiver.
Yeah. Yes. I'm going to do that right now. The what? Tell me. There we go. Mr. Geary and Ms. Mormon, I am aware of that other case. It is the 10 SC case. I believe it's 10 SC 92020. So I will just put it. Do you wish to go ahead and deal with that particular case? Can I, Ms. Mormon, would you like to waive arraignment on both those two cases, the 10 SC case as well as the indictment then under the new case, which is
22 SC.
The 22 SC.
2573, Judge.
22 SC 183572. That's the new case, correct?
You inverted two numbers, correct? 182573.
It's 183572. That's the re-indictment.
Yeah, the calendar has y'all are gonna have to probably correct. See, the clerk has written on the 22 SC 183572.
That's the re-indicted case. Yes.
Yeah, that's the re-indicted case. Yes. Okay, all right.
Okay, so the 10th case is the motion for new trial that Judge Newkirk granted. So the question for me is, do you want me to keep this case along with that case to deal with it, or put that to the side? Ms. Mormon, what would you like with the 10 case?
He said for trial, if after this case.
Yeah, we'll just put it in a trial posture, and put it on a trial calendar. In fact, it can go on that 9.
Because we need to keep account for the 10.
I'll put it on the 9 January 2023 calendar, madam, and I'll probably, unless we've got one, and more than likely I will move it as I get my other trial dates come later this fall, okay? But just for accountability purposes, I'll continue. I'll go ahead and just lump that case with it. But as for the new indictment ending in 572, Would you like to otherwise waive formal arraignment, have the court enter a not guilty plea on behalf of your client, otherwise have at least 30 days from the receipt of discovery to file any motions, madam? Okay, all right. I'm going to go ahead and put it on that 9/23, January 9th, 2023 calendar, okay? And and I'll also track the 10 SC 2020 case, but, or the 10 SC 92020 case. We'll put that on another calendar, okay? All right, thank you. All right. Mr. Greer, you can be excused at this point in time. Your attorney, Ms. Mormons, will talk with you a little bit later on, okay? Okay, oh, do we have a waiver issue with him? Okay. All right. Do you want to go ahead and take that up now?
Yes, please.
Okay, all right. What?
My calendar. Yeah. Mm-hmm.
All right.
Make an additional inquiry, please.
You can.
You had mentioned earlier, asked me to prepare an order. Ostensibly, I presume denying the state's motion to remove Mr. Steele as attorney for Mr. Williams. Both there are 4 individuals who are mentioned in the reason for conflict, and we've addressed one, we're about to address the second one, and the other one will not be addressed until at least the 8th. I would court, whether that's in the law, I'm drafting that order until that's all.
No. Go ahead and do the order for the ones that we have for today. I'll enter a supplemental order when those 2 folks are taken up, okay?
Yes, sir. May I say something else also, Judge?
You can.
Earlier, the court made reference to, I thought to ask some questions, some clarifying questions in regards to our manner of proceeding, and I think I take some exception to the court's belief, assertion at that point that
This is, okay, since you brought it up, no, you may not at this point in time, because you interrupted me to begin with, okay? We're here, Mr. Adams, here's the thing about it. You have to be patient with the court. You have to be patient with the court because I got a lot of freight I'm trying to manage. I'm always going to let you have and consider everything that you tell me and any motions that you file. But what you do is when you jump me, meaning that my procedure, or you jump in front of other people, then that it doesn't sit well. So I'm just going to tell you, if I offended you in any way, please take my apologies for it. It wasn't my intent to do so. I consider you to be a very fine attorney, and I've known you professionally for over 20 years. But having said that, I do get to control the method and manner of how things go in the courtroom.
I understand that, Judge. I have this is your courtroom, but I was asking a question to get some clarification, and I just feel like the court telling me to sit down or what I can do is take my seat was not appropriate. I treat the court always with deference, with respect. And the only thing that I ask is that the court treat me the same way.
I'm required to do that, Mr. Adams. We both are under the rules of professional responsibility.
Yes, sir.
Okay? Anything else, sir?
That's all.
Okay, all right. Okay, who do we have at this point in time? Okay. Let me see if I can get Mr. Greer's waiver. Okay. Let me mark that as the next court exhibit in order. I want to say it's court 3. Is that correct, Ms. Weaver? Yes. Okay, all right. Okay, Mr. Greer, can I get, Ms. Amana, can you go ahead and unmute Mr. Greer, please? And the reason I muted him again, for Cal folks, is because there's a lot of background
Yes,
noise
Your
in the jail. So, yes. Okay, I think he's unmuted now. Mr. Greer, again, good afternoon, sir. Sir, I'm holding at this point, let me go ahead and swear you in at this point in time. Can I get you to raise your right hand for me, please? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God, so affirm?
Yes, Your Honor.
I'll put your hand down. Okay, all right. Sir, I'm in possession of a waiver for you. It's addressed from the law office of Lawrence J. Zimmerman, PC, and I believe it was dated or authored on the 20th of May of 2022. All right, did you have an opportunity to to read that particular document?
Yes, Your Honor.
Or before Mr. Zimmerman penned it, for you to discuss the things that we'll cover in regards to conflict?
Yes, Your Honor.
Okay, I'm going to read it because it's very short. It just says, Dear Brian, I've met with my client, Quantavious Greer, regarding any potential conflicts of interest. He met with you, is that correct?
Yes, Your Honor.
All right, that he being Mr. Zimmerman, right?
Yes, Your Honor.
All right. And you've advised him, he advised you of all the issues regarding your prior representation of him and your current representation of Mr. Jeffery Williams. Is that correct?
Yes, Your Honor.
And then you discussed with Mr. Zimmerman all the issues regarding potential conflicts in this matter. Is that correct?
Yes, Your Honor.
Is that right?
Yes, Your Honor.
Okay, and that you are, you insistent that, or he is insistent that you represent Mr. Williams, and he waives any conflicts of interest. Is that correct?
Yes, Your Honor.
And that it further says, I advised him that the court may ask him questions about these issues on the record. Is that correct?
Yes, Your Honor.
Did he tell you that?
Yes, Your Honor.
Let me just kind of ask you a couple other additional questions, okay? Because this is I just want to make sure that you understand what you're waiving at this point in time. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other? So it could be helpful to somebody else and be harmful against you. Do you understand that?
Yes, Your Honor.
Also, do you understand that the lawyer may want to use a defense theory, witness, evidence, or argument that's helpful to the lawyer's current client, and that would be Mr. Williams, and harmful to you? You understand that?
Yes, Your Honor.
During closing argument, the lawyer may want to argue the evidence against his current client is less than the evidence against the former client. You understand that?
I understand, Your Honor.
All right. Do you also understand that if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client?
Yes, Your Honor.
Do you also understand that the lawyer may have learned something from the former client that helps the current client but hurts the former client?
I understand, Your Honor.
All right. Did you give this waiver freely and voluntarily? Means your own decision to enter a waiver this afternoon as to counsel, waiver of potential conflict of interest as to counsel.
Yes, Your Honor.
And you do so freely and voluntarily. It's your own decision. Nobody's forced or threatened or tricked you into doing so.
Yes, Your Honor.
Have you had an opportunity to speak to fully consider this waiver?
Yes, Your Honor.
And any potential conflicts of interest?
Yes, Your Honor.
All right. Any further inquiry you want to make, Mr. Adams? No, sir. All right. What about you, Mr. Geary or Ms. Rosenwasser? Okay, and I've admitted that is number 3. The letter from Mr. Zimmerman as Court Exhibit 3. Okay, anything else? Mr. Adams? Sir? Okay, all right. can we go ahead and arraign Mr. Williams on the new charge or the new indictment?
Yes, Your Honor, we may.
Okay, all right. Do you want to go ahead and waive formal arraignment, otherwise have the court enter a not guilty plea, and otherwise have at least 30 days to file any motions on under the new indictment, that being 22 SC 183572, sir?
Your Honor, we waive formal arraignment. We do enter a plea of not guilty on the new indictment. We do ask for what the court had granted us previously. Previously, the court had given us 60 days from the receipt of all discovery to file or particularize any motions. We ask for that at this time.
I'll give you 30 days, and the only reason why is because you all have started on the discovery process. I don't know whether or not. I suspect you've probably gotten some discovery, but I'm flexible with that. But let's go with 30 for the time being, okay? Okay.
And Judge,
yes, sir.
Of course, our waiver of arraignment and plea of not guilty is subject to the statements made previously by Mrs. Steele in regards to
I will incorporate those and include those, and I believe that Mr. Geary owes an order in that respect, and we can incorporate that by reference, okay?
Thank you.
Okay, are there any other waivers that I need Mr. Adams, I need to take up in regards to Mr. Steele that are here today? I don't know if there are any, because we...
Yes, Your Honor.
Yeah, Ed Adams is on, and as well as Ms. Merchant, and I think that they have, Martinez Arnold. Let me see if he's on. Is Mr. Arnold, are you on? Martinez Arnold? Are you Mr. Arnold?
Yes, Your Honor.
Okay, I guess he is there. All right. Okay, all right. Let me see if I have his waiver. Ms. Merchant and Mr. Adams, thank you for your patience with us today. I'm going to mark this one as court exhibit next in order, and that would be, I think, courts 4. Mr. Arnold, where are you, sir? Can I get you to raise your right hand for me, sir, if you wouldn't mind? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, so affirm?
No.
I didn't put your hand down. Okay, all right. Mr. Arnold, just want to go through a couple things with you to begin with. Are you aware that Mr. Adams, on your behalf, penned, that is, authored a letter to Mr. Steele on the 19th of May, 2020?
Yes.
All right, are you familiar with the contents of that letter, sir?
Yes, Your Honor.
In terms of the waiver?
Yes.
Okay, I'm just going to go through it with you, and because it's 4 paragraphs, and I'll just read it and ask you some questions as we go along, okay?
All right.
Is that all right?
Yes, Your Honor.
Okay, all right. It says, Dear Brian, I am authorized to make statements herein on behalf of my client, Martinez Arnold. I represented Mr. Arnold in the state of Georgia versus Martinez Arnold, indictment 14 SC 131032, Fulton County Superior Court, which is a case involving a shooting at Lenox Mall. Is that the indictment that is referenced that he spoke with you about?
Yes, Your Honor.
Okay, all right. Mr. Arnold pled guilty to reckless conduct on or about February 18, 2015. That's correct?
Yes, Your Honor.
All right. I am aware of the state's motion to disqualify you, and that would be Mr. Steele, as counsel for Mr. Jeffery Williams in the state of Georgia versus Mr. Jeffery Williams et al., and that was under indictment 22 SC 182273. And that was the indictment at that point in time. Do you understand that?
Yes, Your Honor.
All right, do you understand the case has been re-indicted under 22 SC 183572? You understand that, right?
Yes, Your Honor.
Okay, all right. All right, and that is the matter in which Mr. Arnold, that would be you, as a co-defendant. You understand that?
Yes, Your Honor.
Okay, you have to speak up so I can hear you, okay?
Yes, Your Honor.
Okay, all right, thank you. The motion to disqualify is based in part on the allegation that you represented Mr. Arnold on matters relating to the 14 SC 131032 case. That's your understanding, correct?
Yes, Your
And
Honor.
Mr. Steele represented you in that case, and he's representing Mr. Williams in this matter. You understand that?
Yes, Your Honor.
Okay, all right. I spoke with Mr. Martinez Arnold. This is Mr. Adams, okay? Regarding the state's motion to disqualify you as counsel. I explained to him what the state alleged with regard to you, specifically you, that Brian Steele represented Mr. Arnold on matters relating to the indictment we just mentioned, 14 SC 131032. I further explained to Mr. Arnold, that was you, the relevant law and ethical concerns at issue, and specifically that you're entitled to conflict-free counsel, and that you are representing Mr. Williams in this indictment, 22 SC 182273, which is now indictment 22 SC 183572, in which you are a co-defendant. You understand that, right?
Yes, Your Honor.
Okay. And he explained to you that you can object to Mr. Steele representing Mr. Williams.
Yes, Your Honor.
Okay, all right. And after providing the explanations that we just kind of went through, did you make it clear and unequivocal to Mr. Arnold that, Mr. Adams, that you were never represented him relating to any shooting at Lenox Mall or any other matter?
Yes, Your Honor.
Okay, basically what Mr. Adams is saying is that Mr. Steele didn't represent you in any shooting at Lenox Mall. Is that what you understood?
That's correct.
Okay, all right. Or any other matter, correct?
That's correct.
Okay. All right, and that you explained that he believes that his friends contacted Mr. Steele shortly after the shooting to inquire whether there was an outstanding warrant for you. Is that correct? Say again?
That's correct, Your Honor.
Okay. And you insist that you never spoke with Mr. Steele about the case or any of the facts and the surrounding circumstances, correct?
That's correct. Correct, Your Honor.
All right. Let me ask you a couple of additional questions, just to make sure. Do you understand that the state could offer to dismiss the case against one of the co-defendants, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other?
Yes, Your Honor.
That the lawyer may wish to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client?
Yes, Your Honor.
During closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client.
Yes, Your Honor.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, Your Honor.
And a lawyer may have learned something from the former client that helps the current client but hurts the former client.
Yes, Your Honor.
Do you intelligently, knowingly, and voluntarily waive any potential conflict of interest that would stem from any involvement you had with Mr. Steele and or indictment 14 SC 131032?
Yes, Your Honor.
All right. And you don't have any issue with Mr. Steele representing Mr. Williams?
Not at all, Your Honor.
Did anyone force, threaten, or trick you into entering this waiver?
Yes, Your Honor.
You offer this waiver freely and voluntarily, is that correct?
Yes, Your Honor. Correct.
All right. Mr. Adams, anything, sir?
No, sir, nothing.
Mr. Geary or Ms. Rosenwasser or anything?
Nothing for the state. We believe that satisfies any conflict with Mr. Arnold.
All right, and as I mentioned earlier, if any conflict should develop, please, notify all concerned at the earliest time possible, and the court will also, if I believe that there is a conflict, I will raise that issue and ask you all to address it. While I have Mr. Arnold here, let's see, Mr. Adams or Ms. Merchant, Madam and Sir, would you like to otherwise waive arraignment on the new indictment? Do you wish to be arraigned on that today? Or can we go ahead and do that?
We can waive arraignment on that, Judge, and we filed a couple motions on the old indictment, and then I filed a motion adopting all of those on the new indictment. And I think that would take maybe about 2 hours to be heard. We'd like to have our renewed bond motion heard with those motions. One is a motion to dismiss based on double jeopardy. One is a motion to dismiss based on a statute of limitations violation. And then one is a motion to sever. I think the sever could probably wait, but the other two dispositive motions would probably make sense to be heard at the same time as bond.
Okay. When did you file those, Ms. Merchant?
I filed them in late June, early July.
Okay. If you'd be so kind, you may have already. If you could send Mr. Kearns, my staff attorney, a copy of those as well. And I will take a look at those, and we will determine if I can hear all of them on the 8th. I'll endeavor to do so, but as I mentioned, there's a lot going on. So I'll at least hear the bond. We can wait on the severance, and I'll see if I can hear the other two at that point in time, because I would concur that they probably need to be heard up front. But more to follow on that, okay?
Great. Thank you so much, Judge.
All right. I will go ahead and authorize you to waive formal arraignment, enter a not guilty plea on behalf of Mr. Arnold, and otherwise give you at least 30 days from the receipt of the new discovery or additional discovery to file any additional motions in this case. And we'll hear the motion for, I'll authorize the your motions that were filed in and under the prior indictment ending in 273 to carry over, and otherwise the state's going to file a motion in order for those, and I will adopt those, and I'll authorize your motions to carry forward into the new indictment ending in 572.
Great. Thank you, Judge. And the date on that was the 7th of July. I just checked. Okay.
And that would be, and then I will, it'll be the 8th of September.
Okay, great.
For those motions, okay?
Wonderful. Thank you so much, Judge.
All right. Mr. Adams, anything else, sir?
No, yeah, thank you.
All right. Thank you all for your patience. Really appreciate it today. Ms. Rosenwasser or Mr. Geary, anything else as it relates to Mr. Arnold? All right. Then I will release both of you counsels as well as Mr. Arnold, and we'll see y'all on the 8th of September, okay?
Great. Look forward to it. Thank you, Judge.
Thank you, madam. Take care.
Take care.
Yes, ma'am. Unless you have anything else, Mr. Greer, I think I've excused him already, and I've also excused Mr. Arnold. Yes, sir. You may be excused. Thank you, sir. Thank you for your patience. Okay.
Thank you, Judge.
All right. Okay. Do we have any other waivers that we can address today, or any other people that I have not failed to address as of yet?
Just got On the second calendar, position 4 is Blaylock. He does not have an attorney. He's continuing he's in DOC custody.
I don't think that we have dealt with him as of yet.
He does not have an attorney. He's in DOC custody to provide that.
He is not on the platform today, is that correct?
He will not be.
Okay, all right. We can set him for the 8th of September.
We'll need a waiver. We'll be one of the waiver individuals as well as an arraignment judge.
We can do a waiver and arraignment if he's in fact, if he has in fact counsel. We don't know. I don't think he has counsel as of yet.
Not yet.
Your Honor.
Yes, who's talking?
Hi, my name is LaShondra Bishop. I'm here with Blaylock at Wilcox State Prison.
Wonderful. Okay.
Your Honor, I believe my understanding is he was represented for the purposes of a waiver. I'm not sure if that attorney is here today, but we may be able to do it if that attorney is here. Mr. Lale?
Great Lale. He's joining.
Okay.
I'm here.
Hold on. Let me see if I have you right quick. All right, Mr. Lale, let me go ahead and, there's 1 second here. I'm going to put you. Do you see Mr. Blair? Is there any way you can turn your camera on at Wilcox State Prison, madam? I can.
Yes, sir. Give me 1 second.
Okay, wonderful. Thank you, madam.
Sorry. Okay. Can you see him now, sir?
No, ma'am. I just see Wilcox State Prison. That's all. Let me see if you're showing up any other place. I don't believe so. Let's see.
You still got a camera, I said at the top. Four.
Okay, can you see him now, sir?
Yes, ma'am. I sure can. Thank you very much.
Okay. His last name is
Blaylock. That's my last name.
Blaylock, yes. First name is Damon.
Mr. Law and Mr. Blaylock, thank you for your patience with us today, okay? I am in, Mr. Law, good afternoon, sir.
Hello, Judge. Thank you.
I'm in possession of a letter that was authored by you on the 31st of 2022. That's the one I'm going to refer to Mr. Blaylock and ask him some additional questions, okay?
Yeah, May 31st, Judge. That's correct.
All right. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? Do you solemnly swear or affirm the evidence you shall give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God, or so affirm?
Yes, sir.
Okay. Thank you very much. Mr. Blaylock, I'm going to ask you some questions. I'm holding a letter that I'm referencing that was authored by your attorney, Raymond B. Law, and that would have been on the 31st of May, 2020. Do you recall that having conversation with him about this letter?
Yes, sir.
Okay. I'm going to ask you a couple of questions about it. I know that you had a privileged conversation about it. I'm not going to ask you any specifics about that particular conversation, only the aspects of the representation involving Mr. Steele, okay?
Yes, sir.
Okay, all right. So, The letter reads that he being Mr. Law is writing you pursuant to your conversation on Friday afternoon, May the 27th, 2022, concerning Brian Steele's representation of you on direct appeal from your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in Fulton County indictment number 22 SC 182273, for which you are named as a co-defendant. Is that the conversation that you had?
Yes, sir.
Okay. Hold on one second, folks. I'm having a lot of chatter with somebody. Let's see if there's anybody else. It's Mr. Lyles. I'm going to mute you.
Hello. Hey, this China.
We have some other people on the platform. I'm having to mute because, and that's why we're having some issues with. All right, I think I can hear now. All right, sorry for that, folks. Okay. So, Mr. Blaylock, did you have a discussion with Mr. Law in regards to the issues the court just brought up? That would be the appeal of your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in indictment 22 SC 182273?
Yes, sir.
Okay, and that particular case has also been re-indicted under 22 SC 183572. You understand that, correct?
Yes, sir.
All right. Did Mr. Law advise you, as your independent counsel, that you do not have to waive any issue regarding this potential conflict of interest, and that you can object to Mr. Steele's representation of Mr. Williams if you desire?
Yes, sir.
Okay, I'm going to ask you another series of questions that were not in the letter that Mr. Law penned to you or discussed, but I want to make sure that he did in fact discuss these things with you, okay, to your satisfaction. All right? And
yes, sir.
I just want to make sure. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, sir.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other?
Yes, sir.
Do you also understand that the lawyer may want to use a defense theory, witness, or evidence or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client?
Yes, sir.
Do you also understand that during closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client? You understand that?
Yes, sir.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, sir.
And the lawyer may have learned something from the former client that helps the current client but hurts the former client. You understand that?
I understand.
Okay. After the explanation that Mr. Law gave you, as well as the questions that the court has asked you, and that would have been on May the 27th of 2022, plus the court's questions that I've asked today on the 18th of August 2022. Do you give this waiver knowingly, freely, intelligently, and voluntarily, and waive any potential conflicts of interest?
Yes, sir.
And that it's your desire to do so. Is that correct?
Yes, sir.
All right. Mr. Adams, anything else, sir?
No, there's nothing further.
All right. Ms. Rosenwasser?
Yes, Your Honor. I noticed that the court used the language former client. I want to be clear for the record and for Mr. Blaylock. To my understanding, Mr. Steele is actually still currently representing Mr. Blaylock on Mr. Blaylock's appeal. So it's actually two current clients. So I want to make sure sure that Mr. Blaylock is aware of the conflict arising from the fact that he is currently represented by the same attorney that Mr. Williams is being represented by, and that he wants to waive that conflict.
Let me ask Mr. Adams, okay? Mr. Adams, do you want to address that, sir?
Yes, sir, that is accurate in regards to the appellate matter. Mrs. Steele currently represents Mr. Blaylock, and I do not have any objection to the state asking, I guess, clarifying.
All right, go right ahead, madam. He's under oath.
Mr. Blaylock, do you understand that?
Yes, ma'am.
Do you understand that you are currently being represented by Mr. Steele on your appeal?
Yes, ma'am.
Now, all of those potential conflicts that the court explained to you earlier and used the phrase former client, do you understand that that applies to you as Mr. Steele's current client and Mr. Williams as Mr. Steele's current client?
Yes, ma'am.
Do you still wish to waive any objection to Mr. Steele representing Mr. Williams since he is already currently representing you?
Yes, ma'am.
And do you understand that the matter he's representing you on is related to the matter that he's representing Mr. Williams on?
Yes, ma'am.
Do you still wish to waive that conflict today?
Yes.
Thank you.
Okay, Mr. Law is, I should say Mr. Adams. Who is representing Mr. Blaylock at this point in time? Does he,
I do not believe he's currently represented by him, Judge. I believe Mr. Lael represented him for a limited purpose.
Mr. Law, is that correct? Or Mr. Lael? I'm sorry if I mispronounced your name, sir.
It's Lael, Judge. It's Lael. Thank you.
Okay. Sir, did you, or were you engaged or hired to represent Mr. Blaylock solely for the purposes of the waiver?
That is correct.
Okay, so you do not represent him on the current matter, is that be fair to say?
That is correct.
Okay, all right. Mr. Blaylock, what I'm going to do is I'm going to set your case over for the 8th of September. We'll see if we can still get you an attorney. I can't formally arraign you at this point in time. I'll have to wait until that time, till counsel's appointed, okay? Or if you hire an attorney. So if you hire an attorney between now and September the 8th, you can let us know that. But if not, what I'll do is we'll see if we can get somebody to represent you, okay?
Yes, sir.
All right. Any other issues, Mr. Adams or Mr. Rosenwasser, anything?
Nothing on behalf of Mr. Williams.
Okay, Mr. Law, anything from your perspective, sir?
No, sir, that's all I have today, Judge.
All right, thank you very much for your patience with us today. I know it's been a little bit long time being on Zoom, and thank you, Mr. Law. And unless there's anything else, I'm going to release you at this point in time. Mr. Blaylock, we will put you back on for September the 8th, and hopefully we'll have an attorney by that time for you, okay?
Yes, sir.
All right, thank you, sir. Take care. All right, anything else, or any other folks we can conduct waiver issues with?
I know we had waivers with I don't know if Mr. Stillwell's on the platform today, but I know he had some conflicts, and I saw his attorney here today.
Let me see.
Mr. Stillwell Jackson I have not seen him on the platform either, so I'm not sure if he's here. Mr. Sharp, who represents him, was present.
I know Mr. Sharp was here earlier.
Oh, there he is.
Oh, it is Mr. Sharp. Okay, all right, wonderful.
I don't believe Mr. Stillwell is on the platform.
Where is it?
And one restroom. I don't think he's on the phone with us.
I don't think he was on the, let me see if he is. Mr. Chamberlain, do we have Mr. Stillwell anywhere on any one of our,
I'm sorry, I was just thinking about who we had conflicts for, and that's why I thought of him.
All right, we can put Mr. Stillwell on for the 8th. Mr. Sharp, will that work for you, sir?
It will, Your Honor. I do have a matter of business, and when it's appropriate, I do need to bring to the court's attention, along with the district attorney. as far as,
We can handle this in about 10 seconds, so if I may.
Okay.
Your Honor, and I've told counsel this because of things that will get communicated that are then put into the social media in public. I have informed most of the counsel that I'm communicating in open court because I can't have everything that's happening here be out social media. So Mr. Short asked me a question and I basically responded, I'm only going to respond in open court and nowhere else. I will answer his question without revealing a concern we both have. And I will tell Mr. Shard, at this time, you are clear. There's no conflict there. Okay. And I'll just leave it at that, Judge. I think the issue is resolved, and I've communicated in open court.
Okay. I know that the state filed a motion on that, a motion. Would you be so kind, Mr. Geary, within the next 4 or 5 days to file an order to that effect?
We will, sir. Yes,
Okay, all right.
And multiple copies, too. We're learning.
Yeah, okay, all right. All right, Mr. Sharp, does that conclude, or your issue?
I think so.
Okay.
As long as the state's okay with it, I am great with it as well.
All right, so they're going to do an order, basically withdrawing or otherwise satisfying they have no conflict in terms of your representation of Mr. Stillwell.
No, this is not on the one it's filed for, Judge. This is a separate question that he wanted to bring up to the court that I would not answer. So this does not pertain to the motion that's filed.
Okay. Well, I can't deal with that one until we, in fact, get Mr. Stillwell. I don't think he's on the platform today. So we will have to put him on for the 8th. Okay? For rearrangement and for the waiver issue.
To be clear, Your Honor, so we have a conflict alleged against Mr. Sharp that I think we can relieve through waivers, but we also, Mr. Stillwell has a conflict with Mr. Steele. So as part of Mr. Steele's conflict proceeding, he will also need a waiver from Mr. Steele.
Okay. That's fine. Mr. Adams, anything on that? Is that correct? That's absolutely correct. Okay, what I'll do is, let me put that on for the 8th. We'll get Mr. Stillwell produced at that point in time, and I can deal with the rearrangement and the 2 waiver issues at that point. Edward, you got those down? Mr. Chamber? Yeah, we'll need to put him down for a waiver and for arraignment, okay? Okay, all right. All right, anybody else?
Your Honor, on behalf of Mr. Williams, I think that those of you all ones that were in a position to handle today, Mr. Kendrick and Mr. Stillwell, are the ones that are outstanding that I understand will handle.
Yes, sir. Yes, sir. Okay, are there any other waiver issues that I've not dealt with today, folks? That we were able to deal with, because some people were not, either produced on or not, we're going to get from the state system. We'll deal with on the 8th hopefully we'll deal with on the 8th of September. I also have, okay, hold on. He's not been arrested as of yet, Edward. You're talking about Javorius Bradford?
Yeah, I don't have any information on his name.
Mr. Bradford hasn't been arrested yet. Okay, did we ever locate Mr. Myrick? Yeah, I asked, Lieutenant Dooley was on with us the better part of the day. I believe she had to step away to deal with some other unrelated business. And
I'm back, sir. How can I help?
Did we find Mr. Myrick?
He's on 7 South.
He was on 7 South 113.
Nope, 7 South 602. Let me call again.
Mr. Theory, thank you for your patience.
Welcome, Your Honor.
While we're waiting on that, Mr. Chamberlain, any other holes or inquiry you want to make, sir? Yeah.
You
Mr. Geary?
Judge, on number 17, have you, completed that yet? That's Mr. Nichols.
Hold on, sir.
He doesn't have an attorney to our office, and he's in Rice Street, so we might want to bring him over on the 8th as well to try to do it.
Mr. Nichols, are you on the platform, sir? I don't believe Mr. Nichols, we have him present on the platform. So I will have to bring Mr. Nichols. I don't think he has an attorney either, does he?
No, sir.
All right, we'll put him back on for the 23rd, I mean for the,
9/8.
yes, sir, the September 8th calendar.
Yes, sir.
Hey, Judge,
Sir, madam, yes.
do you have a number I can call you really quickly?
$404-613-8741.
Receive.
Yes, ma'am.
Judge, I think that's
Okay, Mr. Myers will be brought up just a bit. Just give me a second, okay? Go back on the record. The jail called me. They just said that they'll bring Mr. Myers out in just a minute, okay? All right. Is there anything else we can deal with in the pendency? Any other issue? Any other? I
think we only have Mr. Myrick and Mr. Garlington left, and we've got him down as a 2 o'clock appeal.
Yes, man, that's about 15 minutes from now. Yes, okay, all right.
Given that, Judge, may we take 5 minutes?
We can, and I will. Mr. Adams, at this point in time, do you have any, hold on, wait, 1 second. Oh, yeah. Hello? Mr. Adams, any updates on your issue as to bond or to have that? Do you still want me to have that today?
Yes, sir. I've had a chance to consult the co-counsel, the lead counsel. We would like to proceed forward with a motion for reconsideration.
Sure. Okay. All right. Just give me a minute. I'm just gonna recess in place, Mr. Geary and et al. If you don't want to take a break, that's fine. Just come back in about 5 minutes or so. Okay.
Thank you, Judge.
All right. Thank you. We're in recess. Hello. Say again. Hello. We got some clowns now. Clown on that phone. I'm gonna have to probably tap probably. Yep.
I thought of that.
What's that?
You said what? Okay, well, yeah, for about 5 minutes. Okay.
Yes, sir.
I was in AA. She started her girlfriend in the morning.
It's just too much going on.
It is.
There's so much going on. It's all right.
So, I don't even let you know.
Mr. Murray, yep, right here. It's Lieutenant Dewey. Just have a seat, hold tight for me. The judge should be back in a few minutes, please. Thank you. Yeah, I hate this thing. We can't come by here. We can't. Are you saying what I should put him on attention, but that just got stopped. Okay. Because
What do they do? For how long? You inside?
Some of the things that are outside the courtroom. Some of them I don't think so. I don't. But there's things that are outside the court that are being used. I don't believe me. I'd like to know, but I don't. For someone else.
His ball out. Yeah.
Yeah, just be real, brother.
He's coming out next month. You can bring him up, family. They got attitude. They can't come in. Check that out.
Main one went to Africa.
Okay, cool.
One, two, yeah.
I guess 2 days, yeah. I'll do one now.
Just in case.
Yeah. Well, I couldn't have woken up on Monday.
No, this is the case.
I know,
Especially the state.
I think garlic. I'm wondering if Riverside is garlic. Who's carrying it out? Theory doesn't violence.
He's got to do it. He might just be watching. I saw him stick his head in there once. He's probably just watching. There's no reason not to be able to ask questions. I've already from and I think that's not gonna be a hard question to ask.
I don't know if they come here.
We just the only fight is gonna be the university.
Oh, is that my right?
Yeah.
I'm not saying right now.
Right.
The order, yeah, yeah, the other orders. I think, right?
What's left? What we doing now?
Okay, so did you get my answer? Did you get my text?
I gotta listen to
This, I know.
Big money. $1 million guy. Who's River? Who's River? Y'all have a I talked to his mom. Said he used to have straight A's to play basketball. Those just got to him.
It definitely seems like I read the police report. Like you have the police out there. Kind of make comments like, not like that. Something to do.
Something to store. What does this mean?
He's tall. He's like 6'1". They're barricaded like cheap fun escape and out and stop and scream.
That's crazy.
I started off in that, and then I ended up in they had a gang case in Whitaker. And I've been back before.
Big.
She was here. She was the one who did that. I was somebody else.
Oh, yeah. Court can order.
Please be seated, everyone. Okay, let's see if we can find Mr. Myrick. Mr. Myrick? Thank you, sir. It's number 14 on the plea arraignment calendar. All right, good afternoon, Mr. Myrick, good afternoon, Mr. Theory, and good afternoon, Mr. Geary. This is Mr. Theory. Your client was originally brought over an indictment 22 SC 182273, and that matter has been re-indicted in 22 SC 183572. Are you aware of that?
Yes, Your Honor.
Okay, all right. Do you wish to go ahead and waive formal arraignment in the new indictment? Otherwise, have the court enter a not guilty plea on behalf of your client and have at least 30 days upon the receipt of discovery to file any motions?
Yes, Your Honor. We would ask to waive formal reading and to get the 30 days to file motions.
All right, I'll put it on for January the 9th of 2023. Sir, have you filed a motion for bond or anything such as any other motions pending?
Not at this time, Your Honor.
Okay, all right. If you should file any motions, please let Mr. Chamberlain know, and I'll go ahead and we'll see if we can get you scheduled accordingly. Okay?
Yes, I will send courtesy motions to Mr. Chamberlain.
Okay.
Yeah.
Sir, let me just ask you something. Are you going to be asking for bond in this particular case?
It's likely that I will. I will be going to visit Mr. Myrick, and we'll go from there. Yeah.
Okay, all right. I'll wait then, all right? Okay, just want to make sure.
Yes, sir.
Okay, do you have anything else, Mr. Theory or Mr. Geary?
No, Your Honor.
Okay, Mr. Myrick, I'll release you at this point in time. Mr. Theory will come to the jail and talk with you, okay? All right, thank you, sir. Who's got the phone? Huh? The phone. Oh, okay. All right. Is Mr. Garlington with us at this point in time?
He's the one marked River Bend.
Thank you, sir. All right, Mr. Lewis, I'm move you over here. CNN.
Good afternoon, Judge. I'm here.
Hey, good afternoon, sir.
Good afternoon, Judge.
It's been a minute since I've seen you, but
yes, sir.
Good to see you. All right. All right, Mr. Lewis, thank you for your patience. I know you've been on a little bit. Mr. Garlington, given the schedule, was only available as of 2 o'clock since the morning schedule was kind of full. But at this point, he was on for arraignment in indictment 22 SC 182273. That matter has been re-indicted under 22 SC 183572. Sir, are you aware of that, Mr. Lewis?
Yes, sir, I am.
All right. Sir, do you wish to go ahead and waive formal arraignment on the new indictment, otherwise have the court enter a not guilty plea on your client's behalf and otherwise have at least 30 days to file motions upon the receipt of discovery?
Yes, sir, that is our request.
Okay, all right. I will go ahead and grant that. Sir, have you filed a bond motion as of yet?
Judge, a bond motion was filed on the prior indictment. Mr. Garlington is serving out a very for technical violations. So it is moot at this point, but at some point I will refile under the new indictment for a bond motion. Yes, sir.
Okay, when you do so, let us know, and if you would send all those concerned from the state as well as Mr. Chamberlain and Mr. Kearns, the court staff attorney, any motions that you file or any request for bond, we can go ahead and schedule those. I will go ahead and place you on the 9 January 2023 trial calendar. As I mentioned, any other motions that you file in the pendency, please make sure that you copy the court and Mr. Kearns, as the court's not an e-file party, okay?
Will do, Judge.
Okay, Mr. Garlington, Mr. Lewis will be back in touch with you, get you ready for trial, and he'll be talking with you soon, okay?
Yes, sir.
All right, thank you for your patience, and you can be released at this point in time. Mr. Lewis, you have any other business before me?
No, sir.
All right, I'll release you at this as well this time, sir, okay?
Thank you, Judge.
All right, thank you. All right, counsels, were there any other than the bond, are there any other folks I need to take up, or any other people that I've missed? Any other waivers, Mr. Adams, or any other ones that I have missed at this point in time that otherwise are not in custody, or?
No, sir, no.
Okay, all right. Okay, all right. Okay, at this point in time, we're going to take up the matter now in under the new indictment. That would be 22 SC 183-572. I'll note for purposes of the record, Mr. Steele and Mr. Adams, that you did file that motion under 22 SC 182273. I will just continue it and consider it under the new indictment ending in 572, okay?
Yes, sir.
All right, okay. Sir, the floor is yours. Go ahead, Mr. Adams.
Thank you, Ron. Your Honor, on June 2nd, 2022, the court knows, of course, that we had a bond hearing for Mr. Williams on this case. The previous indictment number, of course, adopted now under the new indictment. The court denied bond at that time. The defense put up a number of witnesses and put up live evidence before the court. There were proffers made, and the state proceeded primarily by proffer. Upon consideration of all of that evidence, including representations made by the state, the court denied bond for Mr. Williams. We have filed subsequent to that a motion that is before the court today for reconsideration of denial of bond, and we have put in that motion and are here to argue today that they were consistent, numerous, and material misrepresentations made by the state in opposition to bond. This is not an attempt to cast aspersions upon the motives of the state, but to factually correct some things on the record. We believe that the court's denial of bond was based upon several of those representations taken that the court took from the state. And we believe that if the court were to consider the information put before it without those misrepresentations, then it would appropriately reconsider its decision to deny bond for Mr. Williams. As you recall, also, Your Honor, we placed before the court several options that we believe would have satisfied the court under all of the ILO factors, and did in fact make out mechanisms by which the court can be assured of Mr. Williams' return to court whenever ordered, without going into any tremendous amount of detail. It was a day-long hearing. But, to put it in synopsize it, if that's the proper word. We, of course, suggested to the court that at Mr. Williams' own expense, we would arrange for 24-hour law enforcement monitoring of his residence. We offered to the court that his his residence could be swept prior to his arrival, to make sure that there are no mechanisms by which he could communicate that would not be available or would not be known to either the state and or the court. We suggested that Mr. Williams would be amenable to 24-hour house arrest if he would not leave the home absent court appearance or authorization by the court.
And I did hear testimony from Mr. Charles Middlestat to that extent, and a document was introduced synopsizing, not your word, his or reducing his plan to writing for the court.
Yes, sir. And obviously, I know that the court was attentive and took notes and paid attention to all of the things that we proffered, all of which we believe should have or would satisfy any court, quite frankly, in being comfortable in releasing the defendant on bond so that he would reappear for the appropriate process down the road. As we move forward, however, it's incumbent upon me, I believe, to ask the court to take note of what we've placed in our motion, and I'm sure that the court, as it always does, has had an opportunity to read the motion that was filed on June the 28th of this year, as well as I believe we filed it previously, and we filed an amendment adding some additional information.
Yes, sir.
So if the court has had an opportunity, I'd like to go through some of the things and put on the record what we believe were decided misrepresentations by the prosecution and make some corrections for the court's consideration.
All right, go right ahead, sir.
Thank you, Your Honor. One of the things, in looking at number one, under the material misrepresentations made by the prosecution, that I think the court paid particular attention to was that the prosecutor asserted that the state was in possession of a recorded telephone call from the county jail in which Mr. Williams admitted that he was addicted to drugs and needed to detox. That was a material misrepresentation. This recorded phone call was not played. It was referenced by the state, but we have obtained that, and we sought to get the actual recording from the state, and we ultimately obtained it ourselves and had an opportunity to go through that recorded phone call and listen to it, and listen to everything that was said. Mr. Williams did not make those statements as represented by the state. He did not indicate that he was addicted to drugs and needed to detox. In fact, what he indicated was that he was going through withdrawal from being separated from his significant other. A material difference. And that's particularly important because the court may recall that one of the things that we presented at the bond hearing was the fact that Mr. Williams had been getting drug tested for well over a year, maybe 2 years, as a condition of bond in another matter. That he was not addicted to any substance, he was not abusing any sort of drugs, and then had the state's representation been true, would have flown in the face of that fact that we put forth affirmatively. And so we believe that material misrepresentation was inappropriate, and the court should reconsider based upon that fact that he did not make that admission that would have been of concern to the court. Your Honor, we also indicated that the prosecutor declared, and this is really more in the way of argument, we believe, because there was no factual information put forward. The prosecutor declared Mr. Williams had access to helicopters, private jets, and because of that is a flight risk. That simply is not reality. Mr. Williams does not own any jets, does not own any helicopters, and does not have any greater access. There's been no evidence to indicate he has any greater access to private jets or helicopters or any other means of transportation that anyone else does not have access to. And given that our recommendation was that he be confined to his home at all times, with the only exception being for him to come under the auspices of law enforcement to come to court, we believe that representation by the state was not one and is not one that the court should or could seriously consider.
I believe Mr. Geary did mention that one of his residences is near PDK, Peachtree Cab Airport, and that it wouldn't be much for him to cut his ankle monitor if I gave one, and or money to be to be given for him to be able to make that type of. I think that was Mr. Geary's argument last time, but I understand what you're saying.
Yes, sir. I do believe that my response simply is that Mr. Williams would not have any greater ability or access to do that than any other individual, and there's no evidence that he would in fact do that. Supposition is not sufficient for a reason to deny bond. The prosecutor cited in Overt Act number 4 that Mr. Williams, back in September 9th of 2013, was in possession of a stolen firearm. So I wouldn't consider that to be put that in a different category. I understand their assertion based on the fact that he was charged with that offense. But constitutional guarantees mean more than just words. And in that particular case, I think the state is aware that if the court is not, I can tell you as an officer of the court, that there is no showing that Mr. Williams was knowingly in possession of a stolen firearm in 2013, almost a decade ago. That case is a case where he was charged, and the case was dismissed after successful completion of the pretrial intervention program. Now, entry into a completion of a pretrial intervention program is not an admission of guilt. It is a manner of resolving the case. And I don't mean to preach to the court. The court knows this. It's a matter of resolving the case based on practical considerations. There was never the issue of whether he truly was in possession of a stolen firearm vetted or put before any court or any jury for that determination to have been made. And so because he always enjoys a presumption of innocence, even after he has entered into and completed a pretrial liberation program, I would submit to the court that assertion by the state is not something that could or should have been considered as a reason for denial of bond. Overt Act number 9, excuse me, and this, I won't go through all of them because this actually addresses some of the other arguments made by the prosecutor, specifically in reference to song lyrics. And I know we talked about this a good bit in the last bond hearing, Your Honor, but I really wanted to harken back to that. Overt Act number 9, as referenced by the state, concerned allegations that on April 20th of 2014, there was a song titled You, E-W-W, and that it contains lyrics along the lines of all I ever wanted was the money, and that people wind up in wheelchairs. And the prosecution put that before the court as a way of arguing that Mr. Williams is a danger to the community, as evidenced by lyrics in the song. This and other overt acts that reference song lyrics by Mr. Williams or song lyrics, I think is inappropriate for the court to consider as a reason to deny bond for a number of reasons. Number one, there has been and was not any showing by the state that the lyrics that it referenced, either in that overt act or any other overt act, were lyrics that were either written by Mr. Williams, thereby indicating some sort of mindset on his part, or authored by him, sung by him, distributed by him. I think it is tremendously disingenuous and, quite frankly, very dangerous to take song lyrics where there is no presentation or no representation made about the origin of those song lyrics and use that against Mr. Williams. There are, in this and in several other overt acts, there are, I'm not necessarily suggesting, although it would be a bad idea, that the court, number one, go and listen to the actual songs that were quoted, or that the court do any independent research with record labels to determine who actually wrote those songs or who actually, which artist, where there's several artists in the song, which artist is actually singing the lyrics that the state is referencing. But I can tell you that we've done that. And as an officer of the court, we know, I'm telling you, that we know that there are several lyrics that are referenced that simply are not Mr. Williams. They're other artists. There are several songs that were not written by Mr. Williams. And so it is not just misleading, but it's dangerous to...
So which ones were not written by him?
And there is a song, Anybody, and I don't remember which. I'm going to need to refer to the indictment, where the state quoted lyrics along the lines of, I've never killed anybody, but I had something to do with that body. That is a song that was written by 3 individuals, by Mr. Williams, by Nicki Minaj, I forget her actual name, and a third author. And there are lyrics quoted that were not written in that particular song by Mr. Williams. That is one. There is in Overt Act number 60, in Overt Act number 60, the state referenced a video released on social media titled, quote, "Slime Shit." And the lyrics that are quoted in that is not a song that was written by Mr. Williams. It was a different artist who wrote that song, and none of the lyrics in there can be attributed to Mr. Williams. And my point is...
Who wrote it?
An artist by the name of Roscoe.
Okay.
I can get you the full name if the court desires. Excuse me?
Jimmy Winfrey.
Maybe it's Jimmy Winfrey. I don't know what. I know it's not Mr. Williams.
But anybody was written by Mr. Williams and Nicki Minaj and one other person, right?
That's correct. Judge.
Okay, all right.
And there are some others that I need to go through and search for. What I'm suggesting to the court is that, and I keep using the word dangerous. The state doesn't say that. The state in their presentation says to you that Mr. Williams did this. Mr. Williams said that. Mr. Williams wrote this. I don't know if they said he wrote it. They said he performed what he said. And that's simply not accurate. And so for the court to, asking the court to consider that is dangerous and is inappropriate. It doesn't give the full story, and the court needs the full story and accurate facts in order to make a determination. In one of the arguments that the state put forth, that the court actually took particular interest in, and I'm looking now, paragraph 6, where they reference in Overt Act number 25, they allege that on January 25th, 2015, there was an audio recording of Mr. Williams declaring that, quote, "Sacrifices must be made, soldiers must fall in order for the battle to be won." And the state argued that that was a, quote, "call to battle for criminal street gangs." Now, I will say Mr. Gary, when pressed, was not sure whether this was an audio recording in digital format or possibly a group chat. This was not a statement made by Mr. Williams. And as a matter of fact, I think the court asked Mr. Gary about that on 3 separate occasions, about the format of this statement, where the statement comes from. And so I believe the court was misled in that regard, in them saying that Mr. Williams made those declarations and he simply did not. And it's not accurate. That's information that the court used to make this decision that is simply not accurate information. The prosecutor made a claim that on January 26, 2015, approximately 16 days after the killing of an individual who's named in the indictment, that Mr. Williams released a video stating, quote, "If anybody goes into a courtroom and tells the God honest truth, they need to get effing killed," and that this threat is still being discussed by witnesses today. That was an absolute misstatement of the information that we've been provided with. It's taken out of context. There are sentences that are put together in the representation made to the court that aren't in fact together, and it is put forth as a representation for something that it is not. And again, the state has the ability to give the court the entire, whether it's a social media posting or a recording or anything else, so the court can see it. But making the representations that are not accurate, again, runs the danger of the court being led or being misled about the true contents of any statement allegedly made either by or with the presence of Mr. Williams. and we started discussing a little bit earlier, was the prosecutor saying that Mr. Williams has lyrics in his songs containing references to, quote, killing police officers and judges, particularly, and, quote, mob life. And I don't think that that was inadvertent or unintended. I think obviously saying that this defendant who was before the court for a bond has authored or uttered lyrics about doing damages or killing judges is something that's extremely prejudicial, but it's inaccurate. That is in our paragraph number 9. That is the recorded. That is a statement that was authored by Roscoe as opposed to by Mr. Williams, and it's simply not accurate and not true and not appropriate to say that Mr. Williams is the author of that statement or the person who uttered that statement and have the court consider that as a reason to deny bond. My argument, I guess, Judge, in regards to, and I don't want to limit it on time, but I do want to take my time, but I also don't want to just belabor the point. What I'm getting at in regards to the lyrics is that if you're going to say that those are things that the court should consider, they've got to be accurate. And they can't be misrepresented, they can't be taken out of context, and then they can't pick and choose, pick one sentence from a song and another sentence from part of the same song or another song, and put it together to try and intimate that the defendant has a particular mindset that the court ought to consider in regards to granting or denying bond. Most of the other things that the state argued are matters that I think anyone would consider trial issues. And I heard the court say a little bit earlier that those are issues for trial. Whether or not the person is not guilty, is innocent, or whether someone actually did something that is alleged in the indictment, those are my matters for trial, not matters for consideration of a bond. And there are several arguments that were made, several things, and of course, again, the court has the motion, and the courts have an opportunity to see what we've said in the motion. But they are, the majority of the rest of it are things I would say to the court that we disagree with. We think that given an opportunity to vet them before a jury or even before a court, that we'd be able to disprove some of those things, but those are matters that should be disproved at trial, not at a bond hearing. I'll sit at this point because I've said everything I believe I need to say in regards to our motion for reconsideration. I'd ask the court to give a careful look at the representations that were made, what we have rebutted in those representations, what we have clarified in regards to those representations, and to reconsider the decision that the court made back in June, and also to take into consideration everything that we had an opportunity to put before the court as alternatives for assurances that Mr. Williams will return to court.
All right, thank you, sir. All right, Mr. Geary, or Mr. Smith, or Mr. Rosenwasser, go ahead.
Judge, what counsel harps on about he didn't write this, he didn't write that, where this seems to go is what he just said they didn't want to do. He's basically saying, we disagree with the evidence that's going to be presented in trial. And that, again, as he did correctly state, is something for a different day. The phone call that he got that he wants to classify about someone to his significant other is kind of troubling because the person other in line was the defendant's sister. So if he is claiming that's his significant other, that's just a whole other issue. They can claim that they interpret the call different. The call is what the call is. He claims he's got what he needs for his detox there at the jail. That's straightforward, and it is what it is, Judge. If they want to say it's something else, Again, that might be a matter for a jury to determine what's on the call and what's not, but that's what the call says. That he didn't author the actual songs. Well, as we'll get to the trial evidence, that's not the law. The law is if you sing the song, it's an adoptive admission. You don't have to write them. But that beside it, when he starts saying, when you start looking at Slime Shit and Anybody, I invite the court, look up on iTunes. It says, written by Jeffery Williams. Right? That's everything we see, it's there. If he wants to come in and say, I didn't write that, that's fine. It's in contradiction of what's out there and what is posted as being the truth. Those songs indicate that he wrote them. Now, that aside, it doesn't matter. If he sings them under all law, it's an adoptive admission. So, and the one who said Roscoe, he didn't give you the name on, respectfully I did, that's a Jimmy Winfrey, a member of YSL who's involved in these crimes. Every one of them here want to be a rapper. Right now, there's Mr. Kitchens, there's clearly Mr. Williams, and they're very successful at that. Other members of their gang are writing about the exploits of the gang, and Mr. Williams is singing about some of them. The fact that Mr. Williams didn't actually write that I didn't kill anybody, but I got something in that body, is still biographical. He's still in that role. That's still the truth, and we still intend to prove that, Judge. And again, it's an adopted admission. It doesn't take away anything that maybe he's not the one that penned the words. But again, as listed on iTunes and other such places, it says he wrote the songs. And maybe he's just doing that to get the credit, but he's going to come in and say, oh, that's really not true. Again, it's immaterial. Judge, what this is, and they're saying, okay, he was discharged because he went to pretrial intervention. I don't care. He's still in possession of a stolen gun, and it's still a trial fact for the judge to be able, for the court, the state to be able to prove that he's aware that he knew it was a stolen gun. And the reality of it is, they have so many stolen guns that we have the ability to show that always possessing these stolen guns, they knew or should have known that they were stolen when they get them and how they procure them. That's a trial presentation, and we're going to be ready for that when it comes, Judge. What they're basically saying is we disagree with the evidence, so because of that we say it's a material representation. It's not, Judge. Okay, at least I'll stand in my place as the prosecutor and say it's what we believe the evidence is going to show you. Now, I'm not clairvoyant. Mr. Adams still may get to trial, and they may be right. They may prove that I'm wrong. I may prove, and I intend to, that they're wrong. But that's a trial issue. What the statement said in the call, it says. What this evidence says, respectfully, it says. If those songs are adopted admissions, he sings them. And even one case goes so far as to say, even if another member sings it, it's an adopted admission if you're in there. The same thing with if you're in the song singing about your gang and all your gang members are in there, it's an adopted admission by them as well, even though they're not singing and they didn't write. Judge, I would say that they ignored the law when they argued the points. Your Honor, they argued to the acts of 16, 17, 18, 19, which is the murder of Gunna and Thomas. They want to say that there's no credible evidence and therefore it's prosecutorial misrepresentation. I would ask the court to wait for trial because I was assuming with the fact that there's going to be evidence on it. I'll just put it that way, Judge. Sacrifices must be made. Your Honor, to my knowledge, those are the words of Mr. Williams. In that string, and it's a group chat. To my understanding, I'm wrong twice today, Judge. I could be wrong again, but to my understanding and knowledge, those words are Mr. Williams. So I think what we have here is they've gone through the indictment and they want to reclassify or put defense spin on the evidence in the indictment to say that I'm materially wrong. I still stand behind the representations I made, Judge. And I believe this is going to be the third, if if I'm not mistaken, time they've asked for bond. They were denied bond on 5/11/22, 6/2/22, and I don't know what the court's going to do today. But on 6/2/22, the court denied it on all four bases. And Judge, we stand behind the representations we made. To my understanding and belief right now, they were all correct. They might have a different spin on them. They might be telling or forecasting what their trial strategy is to fight the evidence. But again, that's a trial strategy. And I can tell the court, I'm sitting here looking right now at one of the ones for slime shit, and it says written by Jeffery Williams and Ricky Harrell, Harrell. That's wrong, that's what he's putting out. If he wants to change it, there's nothing I can do about that. Judge, we'll deal with it when we get there. Your Honor, he runs, and I mean he runs, he's the general. He says in the song, he's the general. He runs a very violent street gang that has committed numerous murders. Respectfully, Judge, if he's let out with the number of people that are still out there in YSL, I would expect that to continue, and I would expect witnesses to be in danger. Again, I have nothing specific that Mr. Williams has made a direct threat. This is the gang, members of the gang, relations of gang members here that are in jail on this case have made them. One of them is actually in jail for that threat. And I don't know the way to put it, I don't mean insult the court, but this is the real deal, Judge. These are very violent people, that are dangerous people, and I believe the finding on June 2nd was correct. We'll flush this out at trial, but all four of those factors still apply. There has been no material change. There has been no misrepresentation. There's a disagreement with what the evidence at trial is going to show, and I believe then that means they do not counter the order that the court signed on June 2nd. They do not carry their weight on the LL factors, and I ask the court to deny bond again.
All right, thank you. Yes, sir.
Yeah.
You may.
Again, Your Honor, thank you for everything. Thank you for everybody. Your Honor, I'd like you to please grant bond for Mr. Williams. I believe, without any hesitation, there are conditions that can be fashioned that will ensure that Mr. Williams comes back to court when required to do so, not intimidate a witness or be a danger to the community, remain proper in the community, will not commit a crime while out on bond. I had the benefit in my life of knowing Mr. Williams for almost a decade. I saw his rise to international prominence in his field of choice of law. I also have had the honor, shock, to go into the neighborhood that he was raised and other people who come from poverty. I'm sure the court has. He has been shot. He has been hungry. His family held it together as best they could. He grew up in a place that in America, 1990s, nobody should grow up like that. And he's being ridiculed now because he talks about that life and what he's seen. He shouldn't. He's bringing, people do hip hop and rap, are bringing to the attention of people who have no idea what it's like to be in the inner city growing up. He is educating all of us. He should be applauded, which he is. Applauded by most. The fact that we are talking about lyrics and songs is to me, and we're going to get a motion from you, Mr. Adams, to please keep it out. It's admissible evidence. Because I don't see that happening to people who write books. I don't see that happening to people who act in movies or produce movies. I don't see it happening to people who paint portraits. But it happens in music only to people who perform hip hop or rap music, which to me is discriminating. Because I don't see it happening to people who do rock and roll or country music. Same type of lyrics. Jeffery Williams, Your Honor. I know you don't have the pleasure of meeting him. But you've heard him today, you've heard him before. He's most polite. He's a genius. He understands that we're fighting for his life. He would not risk anything on bond. The fact that Mr. Geary, and we all agree, everyone says these are trial issues. They are trial issues, but Mr. Geary wants to use them as bond issues. Mr. Williams is presumed innocent of any crime. He has no history. And while Mr. Geary said we can disagree and he will defeat us or we'll defeat him in a trial, that's fine. But at a bond hearing, we shouldn't even be talking about the allegations in the indictment. Those allegations are what they are. They're hearsay evidence that Justice Huntston taught us about that are just put into an indictment and affirmed by a grand jury. So the real evidence you have before you is you have a young man who sits in a Cobb County Jail. I see him almost every day. And we work his case every day. And he should be in a house without any internet, without any electronic data, without any access to anyone, except his lawyers or, God forbid, a medical emergency, with sworn law enforcement officers surrounding that house. And we can move him out to the country where no one's around him. We can secure his place and no one knows where he is. That is more humane. I ask you to please grant him bond. I will tell you, I will go visit him every day. If anything happens, we can put somebody from the district attorney's office, from the court system, from my office, from Mr. Adams' office, in charge of ensuring that those officers are constantly updating everything, and there's surveillance cameras that can be there. Your Honor, Mr. Geary, he knows my feelings for him. He is wrong. He says that Mr. Williams is on some sort of chat group talking about soldiers and people, sacrifices must be made. I have it in discovery now. I didn't have it when you originally heard the body. So I sat there and I didn't say anything because I didn't have the information. But I have it now. I can show it to you now. Mr. Williams is not on that chat. And I heard Mr. Geary say he may not be right, he may not be on it. I'm telling you he's not. I respectfully ask you, Brett Bond, Mr. Williams has been targeted for about 7 years by law enforcement. He is in this case by shooting at a bus as a co-defendant. Mr. Geary is the one who prosecuted Mr. Williams in Cobb County. Mr. Williams was not indicted in that case. He's indicted now. There are problems with this case for the prosecution, and the problems are not solved by a January 9th trial. Every day in jail is a day and a day. I want to thank you, and I hope I'm making some sort. I'm not trying to waste your time. I'm just
not wasting my time. It's your job. I mean, and with any of this, look, there is natural friction between the court, the defense, and the state or the government. That's healthy. So your statements to me, Mr. Adams' statements to me, Mr. Geary's statements, anyone, I understand it. I understand what they mean, and I understand, what my role is in this. And we're going to disagree on certain things, but you can't, no harm in asking. The court doesn't feel offended. The court has the responsibility to listen to whatever's proffered in front of it. And I take that responsibility very, very seriously. And I also understand that with any criminal accused who is pending trial, they are presumed to be innocent. So I understand that, Mr. Steele, and we may disagree sometimes or disagree, and I'll make rulings, which you certainly, as I always tell people, you can have my homework graded. That's the beautiful thing about it. and I won't feel offended at all.
I know there has to be, under the way that Mr. Williams has access to resources, there has to be a way to allow, satisfy the sovereign court that he can be granted bond, and then with all conditions. They'll put him in a jail, but just outside the jail. And he doesn't have to have any type of communication with anyone else. We don't need that. He is in such a bad position now. Anything would be better. It would be better for preparing the case as well. I know that it may not be concerned for the court, it's concerned for me. With that being said, Your Honor, you said last time, before you're on the court for a motion for bond, you did all four factors and satisfied. You said the primary ones, group chat messages from 2015, the fact that the threat, that message is still being talked about. That message, Your Honor, is a statement that is reality. The court sees it, the prosecution sees it, the jury sees it, everybody, news media sees it. All he said was, I don't get it. People lie to their mothers, lie to their fathers, lie to their brothers and sisters. And then they come into court, raise their hand, and swear to tell the God's honest truth. Those people should be killed. Talking about, if you look at the date that was made, January 26, 2015. It was a well-known case right then that an innocent man spent 30 years in prison based upon the lie of a well-known town liar. And 30 years later, it was proven innocent. The district attorney's office dismissed the case. And that should not be a reason to deny Mr. Williams a bond. And in the background, when you blow up that recording, you hear people saying, I'll swear to tell the truth, and then I'll lie on God. They're talking about witnesses lying together. That happens. That's not a reason to deny bond. Your Honor, we will stand in court in any type of condition. He will not leave that house, but he should be respectful. Mr. Williams meets those four parts. Respectful. I ask you to grant a bond that he cannot leave, he's surrounded, and he will be embraced, and the only people that can visit him are people approved by the court, and the district attorney will know about it, and the defense team. And that will be it. And that was hardship on his family and his friends, but so be it. You can't see anybody now. I want to thank you.
You're welcome, Mr. Steele.
Can I respond?
Yes, you may, sir. Yeah.
A new point was made up and being targeted by police. I don't find that any real change. And the concern is when they say he's nonviolent, is this. I want to remind the court one of the reasons we re-indicted was to add the charges from the arrest on May 9th. And one of those charges is the possession of an automatic weapon. And there are other weapons in there. Now, as we stated, Mr. Williams is not a convicted felon. He can have weapons. He can't have an automatic weapon. And there's other drugs located in the house. And I believe there was also a small child in the house there with those weapons and those drugs. Your Honor, quite frankly, the case that we see and the person Mr. Steele just spoke about, those things don't do this. They're not. That's not accurate. This is a dangerous person, and I don't. Mr. Steele's got a job to do, as the court said, and I respect both Mr. Adams and Mr. Steele for doing the job. But that's not real. The real world is where we live in here in Atlanta. And YSL is a dangerous gang, and this is the man who leads that gang, and he's dangerous. And I ask the court to reaffirm your findings from June 2nd and deny bond.
All right. Yes, sir.
find the last item that was raised about it.
Sure. Can you do it in under a minute? Because you will wax on if I don't cut. I'd give you a timeline.
Yes.
Okay.
14, the 14-year-old child, Mr. Williams, has custody. That's his son that was in the home on May 9, 2022. The gun that Mr. Geary is talking about, law enforcement officers surround the house. They were not in uniform. People in that house, multiple people actually, 10, 12 people in the house. My number may be a little wrong, so I apologize. There's surveillance around the house. The person exits the house, not Mr. Williams, with that gun. That's not Mr. Williams' gun. So to sit here and say it's Mr. Williams' gun is wrong. And that surveillance video, I presume the police have it because they don't use the home. In addition, Mr. Williams self-surrendered to them. He called me. He said the police are surrounding my home. I said, surrender. And I'll come over. He said, okay, that's what he did. And then finally, Your Honor, I hear Mr. Geary, he tells me this, he tells me off the record, not on the record. He always tells me the same thing, Mr. Williams is in charge of this gang. Mr. Williams is a role model to most. He is a non-gangster, but he grew up in an area that he understands that lifestyle. But he is an artist, business person, father, and son.
All right. I'm going to take a few minutes, Mr. Geary and Mr. Steele, Mr. Adams, Mr. Smith, and Mr. Rosenwald. So just give me a few minutes. I'll come back out in a minute, okay? All right. We're going to be in recess.
And you got sick leave.
I was just making sure you got paid in this one.
What end?
But anyway, it's, yeah, I'm just not doing this first name. It was flat? Yeah.
We were told on the phone call.
Sure did materialize.
A bunch of them.
I can't believe all this.
You waiting on him? I've seen you
No, I think it
Oh, because that, again, it must be. No, because I remember we did all our own here. I remember here.
Mr. What's his name? He rolled up in his chair. It was great.
Yes.
We happened to, I mean, there are so many number of lines, but at one point, Coaching and I had a next question. What was his name? You know what I'm talking about? He was stalking his ex-wife.
One crazy one.
That was really great. One of his
That's the one that was in the house.
Yeah, that was a different one.
That was a different, yeah.
This was an old one. This was an old one. It was just before it's time for him to he was getting the art license. The architect.
They were trying to literally go for one time. Stop it. I'm just going to run all the way. We didn't see how was nice and nice. They'll be having these conversations. What's the crap? That's how we talk. Oh!
And there was the one with the boxer. And that was the
Basically.
Yes.
He had the gun, hit the gun, everything, get away.
Had I don't remember, but it's white.
She was one.
Yeah, just like that.
Yeah.
That was one of these secrets. I think it was a motorcycle.
He's like, you can't be about that. There's no asshole to fix
Yeah, you know, he said, because he's, I still remember that. Yeah, but it was the motorcycle.
But a nice one, a big nice baby.
I'm talking.
Oh, no. That's right. The scene, the shot, the scene had a little knife. I was playing myself to get Yeah, it was like an inch and a half away or something.
Do you ever look at the website? Yeah. How many questions are in there? Because I want to look at what's in Paris.
I'm sure you did.
This is wonderful.
Please remain seated for the order.
Please be seated, everyone. Christina. I've had an opportunity to reconsider the defense's additional pleadings that were filed in this particular case on motion to reconsider bond. It was filed on behalf of Mr. Williams. I have considered those arguments under the new indictment of 22 SC 13572, even though they were filed under indictment 22 SC 182273. And I've considered the proffers made by the state. I've considered the arguments of the defense. At this point in time, though, Mr. Adams and Mr. Steele, I am still not convinced that that what you've argued, or what you've continued, or what you've argued anew and taking into account what I have heard already, I still believe that the court, it is the court's decision that the four factors under consideration, that I'm going to deny bond at this point in time. It is not lost on me that your client's in custody. Not lost on me, your client enjoys a presumption of innocence. I respect all of you as seasoned advocates. And I understand fully that there are differences in bond and differences in what may be pled at trial. And I understand that you all as defendants don't have any responsibility at all to present anything, that the government has the responsibility to present and prove everything that's alleged in the indictment and the elements therein to a satisfaction of beyond a reasonable doubt. So that will be decided later, but at this point in time, under Title 17 and under the case law that's been argued thus far, I am not going to grant bond at this point in time. Bond will stand denied. All right, is there anything else I need to kind of go through with you all at this point in time? Mr. Adams or Mr. Steele, we have proffers. The remaining proffers, I will attempt to try and get those folks here for the 8th of September who are otherwise unrepresented or maybe in the Department of Corrections. Anything else? And I understand you all have some motions you're about to file. If you should, for whatever you file, please send courtesy copies to myself and in particular Mr. Kearns and Mr. Chamberlain, so that because we're not an e-file party, the court is not an e-file party, and that's the only way we'll get those. And upon getting those, I will figure out a date and schedule you all for any motions that may need to be heard or issues that I need to take up, okay?
Yes, sir.
All right. Mr. Geary, anything? Okay, we have dates, and Mr. Geary, you owe me, I believe that you have presented orders. I have signed those. Mr. Chamberlain should have given those back to you. You will file those, e-file those for the null process in the case.
Adopting the motions, Judge.
Yes, sir. Just want to make sure I have the right indictment. Under the old indictment, that would have been 22 SC 182273, and the motions that have been filed on that will be carried over into the new indictment ending in 572. Yes. So I'll need that, and We have several matters that will need to be taken up on the 8th of September. Mr. Chamberlain will go ahead and publish or send out notices for that. Mr. Chamberlain, anything else, sir? Yes.
I've been here all day, so I have not got a chance to confirm. But I can send them for all the individuals that I know that are unrepresented and in DOC custody.
Just can I say something?
Yes.
In the future, I've shared information with y'all. If y'all have information that I do not know about, please give it to me.
In particular, custodial information. Yeah.
Because we could avoid it.
And what I will do, Ms. Rosenwasser, if you would go ahead and I know that you all have told me which individuals are not represented, but if you will roll that up, and I think you may have done that while we're sitting here.
Yes, Your Honor. I think
I'll go ahead and I will go ahead and include all of you on an email. I did receive an email from bear with me. Please bear with me. From Miss Vanessa Carroll, she's an attorney with the Southern Center for Human Rights. People are very interested in this lack of C3 representation. So I will go ahead and send out another email to Miss Bernard and the folk and Miss Ali, and send out something to see if we can get some movement with that. And if it goes much further, I'll have to relook the situation. I may have to ask the county for some funds to appoint counsel to represent folks who are unrepresented. But I'm not going to let it go much longer. So that's still on my radar. All right, anything else? Okay, then, everyone, I appreciate your patience. Mr. Adams, I apologize to you again if you felt, for any slight I may have given you, and know that all of you are held in high esteem in the criminal justice system in terms of your advocacy and ability as advocates. Okay? Okay, all right. At that, we're in recess, all right?
Yes, sir.
Okay.
Whoever has time tonight, I'll send you an email.